Ask the next circuit to do it. Yes.
I'm for the
Today
respondent.
is the last day. What can we do? Yes.
May I have with
Number
some
one.
trepidation?
This will Lordship.
Yes. Yes.
May I have my lords kindly to mention item number 35 of my lords yesterday's
Hey,
list.
it is sort of a box. Huh? Yes. Item 35. Yes, Mr. Das.
Of yesterday's list. The urgency is this, that post dismissal of my writ petition
No,
against
Mr.
which I
Dasgupta, today we cannot add any other matter. Sorry, no. Sorry.
Lordship.
Next, please mention it. Yes, call on the list. One দিয়ে তো শুরু হয় generally. ডাকো, ডাকতে বললাম list.
Your Lordship,
Yes.
I'm for the respondent.
Yes.
Your Lordship, kindly see the order dated 30th.
What is
July.
the correction you want?
On the operative portion of the said order, para 15, it
Yes.
has been stated that the appellant shall maintain proper accounts of the restaurant cum bar business only has been mentioned.
Oh, that you said
Whereas
hotel.
Hotel, restaurant cum bar business and foreign liquor. FL.
Bar includes foreign liquor.
No, sir, they are.
Non-mention of this does not mean anything.
Hotel and foreign liquor.
Whatever is there, both of you know what is running there. So what is the question of, restaurant car bar, we write, whatever we write, whatever is there, you provide a furnish action, their furnish action.
Page number 209. They have the said license in that name.
Learned counsel for the, you are for the?
Respondent.
Learned counsel for the respondent submits that in the order dated July 30, 2025, comma, it had been mentioned that the appellant shall maintain proper accounts of the restaurant cum bar business being run from the suit property. Whereas the license is for hotel cum restaurant cum bar, including foreign liquor business. So next para, we do not find any reason to unnecessarily tinker with our order dated July 30, 2025, comma, since it is understood, it should be understood by both the parties as to what business is running from the suit property. And it is nobody's case that there are different businesses running in from the suit property apart from the one which we have mentioned. Full stop. Hence, comma, the mention of the business as restaurant cum bar business would not affect the tenor of the order, and it would be construed that the license, that the order refers to the hotel cum restaurant cum bar business, including foreign liquor. This would be
Obliged to Lordship. Obliged to.
yes. What is the correction, Mr. Mukhopadhyay? Oh. He mentioned procedure. Mentioning slip কোথায়? Mentioning slipটা দেখি। Mentioning slipটা কি? এটা কে? কোন অ্যাপ্লিকেশনটা বলো তো? কোন জায়গাটা এখানে কি গেলে আর কি লিখতে হবে? আর কি লিখতে হবে? T21 তিনটি তো রেফার করা আছে। না না দিন ফাইলটা দিন। Mr. Mukhopadhyay, you had not mentioned.
Lordship.
You had, why?
Lordship, it will be CRA DBB 1 of 2025. And in para number 3, your Lordship, learned senior counsel appearing for the petitioner in, over here it is CRA DB 77 of 2024. That was, this is of different one, your Lordship. Our matter was CRA DBB 1 of.
Senior counsel means Mr. Shobhushachi Banerjee was appearing.
Yes.
CRA DB.
Yes, your Lordship. In para number 3, your Lordship.
77 my matter.
Yes.
Title number 2.
Very well. In paragraph number 3 of the order dated July 31, 2025, comma, CRA within bracket DB 77 of 2024 shall be read as CRA within bracket DBB hyphen B bracket closed 1 of 2025.
5. Yes, sir.
So let this order be deemed to be a part of the order dated July 31, 2025.
Obliged, your Lordship.
Madam, for the petition.
Yes. Habeas corpus.
Well, a victim has already been recovered.
Statement.
164 of the victim has been recorded, madam, completely gone.
You are dropping the habeas corpus.
May I get one copy of the report?
Are you entitled? Otherwise, investigation is going on. You will refer to it. You are not entitled at this stage.
Good.
Learned counsel for the state. Should you refer to a state or what? Or particular authority? State. Learned counsel for the state submit a report indicating that the statements under section 183 BNSS, both of the victim lady only, of the wife of the petitioner, that is Srimati Sujata Bormon, has been taken, where she indicates that she had gone willingly with Taposh Kundu, with Sri Taposh Kundu. As such, there is no scope of passing further directions in the habeas corpus petition, since the whereabouts of the wife of the petitioner have clearly been disclosed. Full stop. Accordingly, WPA within bracket H of within bracket H bracket close 4 of 2025 is disposed of in view of the same having been rendered infructuous in the light of the above observations. Full stop. It is made clear that the investigating agency will be at liberty to take the process of investigation to its logical culmination. They may be filing an effort or whatever.
Extremely.
Thank you. The reports filed today, the statement filed today be kept on record along with the connected communication by the officer in charge of the concerned police station. Thank you. Opportunity or name. মিস সরকার আগের অর্ডারটা না একটু চেঞ্জ করে দিন, যেগুলো ফাইলগুলো সেগুলো ফেরত দিয়ে দিন, স্টেটমেন্টগুলো। যেখানটা লাস্টে বললাম না শুভ্র, যে ওই ফাইল টু বি কেপ্ট অন রেকর্ড, ওই অ্যালং উইথ দ্য বললাম, ওইটা হবে দ্য স্টেটমেন্টস ফাইল টুডে are returned to the learned counsel for the state for taking appropriate steps in the investigation. Full stop. The connected communication by the concerned police officer be kept on record. We are returning the statements. Learned Badir is right on that because they are not entitled to that copy. Yes. ঠিক আছে। What? Yes, limited purpose in interim order, but we need to know what is the.
Yes. Then I'll be very precise, Millard.
Yes.
Maybe 10 minutes.
Yeah, because today, because the difficulties, our officers will also leave
Yes,
today
yes.
because they were already scheduled to leave yesterday.
Keep it very.
Now we have kept them for these matters only.
I understood, Millard, completely. Millard, page 30, Millard. This is the first notification.
Yes.
Millard would find, Millard, it is dated 9th of September 2019.
9th of September 2019.
In exercise of power conferred under Section 2 of the Police Act 1861, read with Section 2 of the Bengal Police Act 1869, the governor is pleased hereby to constitute with effect from the date of this notification a special task force in West Bengal with headquarters in Kolkata headed by so and so. Next paragraph, Millard can skip over as of now. The last paragraph is important, will deal with the various nature of offences. So there are 8 offences which are enumerated. Now, Millard, I have annexed the Police Act, Section 2 and Bengal Police Act. Just Millard would have a glance at it at page 33. The powers which they say in exercise of which the STF is being constituted. Section 2 of the Bengal Police Act, page 33. Constitution of the force. The entire police establishment under a state government shall, for the purpose of this act, be deemed to be one police force and shall be formally enrolled and shall consist of such number of offense officers and men as shall be constituted in such manner and shall from time to time be ordered by the state government subject to the provisions of this act, the pay and other conditions of service. Now, Millet, straight away, Millet skips over a few pages. Millet would take Millet section 2 of the Bengal Police Act, which has been referred to in the notification. That Millet would find that Millet page 52. The Bengal Police Act 1869. It shall be lawful for the state government from time to time to divide the states into as many general police districts as it may think fit, and from time to time to vary and alter any of such general police districts, or to consolidate 2 or more of such general police districts into one district as it may think fit. Now, 2 provisions Millard had looked at. Millard, I do not find any enabling power conferred by these 2 provisions upon the state government by virtue of which a specialized force can be created. Kua, Millard would compare the specialized central government forces, each one of which is Millard constituted by a piece of legislation. For example, the BSF, the SSB, or any other force is always created by a legislation. And the acts, the provisions which has been mentioned in the notification probably does not confer any power upon the state to constitute such a force within a force. Now, Millard, for the time being, Millard, keeping this aside, Millard would skip over to page 55. This is from where our grievance starts. Page 55. This is Millard, a notification dated 28th February 2025. This was gazetted on 28th February, the notified on 30th January 2025. In exercise of powers conferred by clause U of subsection 2 of section 2 of the Bharatiya Nagarik Suraksha Sanghita 2023, the governor is pleased hereby to declare that the places mentioned in the schedule below as special task force police stations, and also specify the local areas of the said police stations for the purposes of investigation of the offences mentioned in the said schedule. So, let 2 police stations, places which are already under an existing police station, 2 additional police stations are being sought to be created. And the purpose, Millard would kindly, Millard, I lay emphasis on this, for the purposes of investigation of the offences. Now, Millard would find 1 special task force police station having address at Salt Lake, so-and-so, jurisdiction, local area, the entire South Bengal. And secondly, special task force Siliguri police station having address at so-and-so, the entire North Bengal. And at the right, offences to be investigated, Millard would find 7 offences, which is in variance with the original notification.
So the effect is that if the offence is under these provisions, then it is the task force which will be in charge of investigation of this of all of Bengal, basically,
all of Bengal.
between them.
All of Bengal. So, two police stations will take up all investigations
Under
if the
this
offence pertains to these offences. This is the effect of this notification. Now, I'll come to the law later. I'll just my grievance. How
BNSS set out.
Yes. Now, Millard turn over to page 56. Section.
Give us half a minute, Mr. Ghosh.
Yes.
Now? Yes, I'll run over.
I'll place the provisions.
No, we'll come later. We'll just taken. Yes. Which page?
Page 56.
Yes.
The second paragraph. This is another notification immediately thereafter, 31st January 2025.
This has not been notified in the Gazette?
Probably no. This is Millard, a general notification issued by the Deputy Secretary.
All right.
Now, to the second paragraph, why I am placing this notification, the second paragraph throws further light as to why the police stations were sought to be created. To enable the STF West Bengal to register FIRs in respect of the specified offences assigned to it, and for enhancing the effectiveness of STF West Bengal, 2 dedicated police stations, so-and-so Special Task Force Headquarters, Nabodiganto Bhavan, and Ambikanagar, Jalpaiguri, the Siliguri police station was set up by notification dated so-and-so. Now the governor is pleased to accord sanctions. So, Millard, the sanction strength of the police stations, the pay scales, etc. has been dealt with. So, Millard would find 2 purposes we can get. 1, for the purposes of investigation. 2nd, for the purpose of lodging of FIR. Now, Millard, my principal grievance, that is at page 57. This Millard, the Deputy Secretary, writes to the Principal Secretary, Judicial Department. This is on 10th February 2025. I am directed to refer to your letter dated so and to say that 2 special task force police stations under West Bengal STF has been created. Write this department notification dated 30th December 2025, which your lordship has seen. Now, the aforesaid 2 STF police stations may be brought under the respective jurisdiction of criminal courts for trial of specific offences as per the proposal bill. So all cases which can be looked after by Navadiganta Bhavan headquarters police station shall go to SEJM Bidhannagar, the extreme right column, and the ADJ Special Court West Bengal, MP and MLA cases at Bidhannagar, North 24 Parganas. 2. The Special Task Force Shiliguri Police Station, the SCJM Shiliguri and ADJ 2 at Shiliguri, North 24 Parganas at trial court for conducting trial of all sessions cases. So,
All right.
so the entire original jurisdiction on the principle of territoriality, which is the foundational basis of criminal jurisprudence, has been given a go by.
So
8.
therefore, the effect is that if an FIR is lodged in one of these police stations, investigation will come later on.
Yes,
FIR is registered in one of these police stations,
yes,
it will automatically go to these courts.
right.
I mean, rather, yes, these courts will have, but
These courts.
these are courts. Oh, acha, only yes. Oh, all right.
For entire North Bengal, 1 court, for
Ah.
entire South Bengal, 1 court. Now, Miller kindly takes the BNSS ones.
So therefore, if it's an offence under any of these provisions, previously what used to be is that the complaint is lodged with the particular police station having territorial jurisdiction, and that police station, whatever happens regarding that, everything in this court, the court would be the respective territorial courts.
Absolutely.
Now it has to be registered also, complaint also to be the register, at least the FIR has to be registered by that court,
Yes,
which necessarily means the complaint also has to be lodged there.
has to be lost there.
And the court having jurisdiction will be only these 2 courts,
Only this court. Now,
thereby
now-
overriding the territorial.
understanding the genesis of the CRPC.
Let us see the provisions. you are-
Yes. Now, Millard, first, I will place section 173. Or Millard may take 175. 175 first.
Yes.
Any officer in charge of a police station may, without the order of the magistrate, because this will cognizable cases, and since the offences of high gravity, we are presuming all would be cognizable offences. So I am placing 175, skipping 174. Without the order of a magistrate, investigate any cognizable case which, this is very important, which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of section 14, chapter 14. Chapter 14 deals with jurisdiction of criminal courts. And the power of the police officer to investigate is circumscribed by the same principles as that of chapter 14 of the code. Now, Millard, kindly, now Millard takes chapter 14 once. From section 197 onwards.
Yes. Yes. Once 97 is clear.
Yes. Ordinary place of inquiry and trial. Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Now, 199 to 204 deals with the exceptions to this general rule. What are the exceptions that Millard would, Supreme Court has dealt with it? Millard kindly takes my pleadings in the writ petition. I have, Millard, summarized what has been laid down by the Supreme Court.
But here that these scopes are not left because it has to go to those courts for the first.
Absolutely. Now, exceptions are what? When an offense is committed, offender is apprehended somewhere.
It cannot be on a general basis.
It cannot be on a general basis specified within the contours of the BNSS or the CRPC.
If these situations arise, then of course.
Yes. Now,
That would happen even today, whatever it is, without this notification.
right. Now, Millard, it's a fundamental principle of law when consequence of a particular non-compliance in a legislation is provided in that act, that has to be treated to be mandatory without any deviation. Now, Millard, 508 of the BNSS deals when the trial would be void. And it says when if it is tried without jurisdiction, the entire proceeding is void. Although there is a saving clause, Supreme Court has interpreted this has to be applied post facto, not a priori approval or a permission or a grant to a government to do something to violate the law and then get it regularized. So what the notification contemplates is a trial which is otherwise would be void under the CRPC or rather the BNSS.
There's some provision in the BNSS, I don't recollect right now, that it would not be an investigation would not be vitiated merely because it's the magistrate have taken cognizance read with 223.
Facto.
So that you were saying. That you were saying post facto.
Yes.
After taking
after
from the stage of taking cognizance.
Yes. Yes. Even if the trial has been completed.
Yes.
Even if the trial has been completed.
So that cognizance, 223 cognizance, 223 read with the other provisions, that cognizance won't be vitiated merely because it was filed in a wrong jurisdiction. But that's a different concept altogether.
That's a different concept altogether. And that's why I have dealt that in my pleadings in the writ petition that the saving clause is of no rescue. Because the Supreme Court has said it is always post facto, exceptional case. Somehow it has happened. Would that mean that 10 years of trial, 5 years of trial will go to the air? No. That's why the act provides it's not a priori permission or an approval.
So this says no finding, sentence or order of any criminal code.
Correct. Correct.
So that's all post facto.
That's all post facto. We are Millard on the power of lodging an FIR and the power to investigate.
And the practical difficulty will be somebody wants to lodge a complaint, he has to go there. I mean,
yes,
from
yes.
Suppose.
And Millard kindly contemplates the consequences. Offense happens in Kalimpong, Kuchbihar. All the witnesses has to be taken there. And I commit an offense under the NDPS, Mr. Chaudhary commits an offense under the NDPS. His offense will be graver. There's no doubt about it.
Presumption will be.
Presumption will be there. But I will be.
You are the usual scapegoat.
I am investigated by the police. I have a different treatment in law. And he is investigated by the STF. He has a different treatment.
So why different treatment? Both of you have to go.
No, if the police investigates, STF does not have exclusive jurisdiction. It's all pick and choose. A particular case STF wants, I want to investigate into this case.
No, STF has been given exclusive jurisdiction by these notifications.
Probably not.
Well, let's see that also.
Yes, probably not, Millard, because the general power of the police to investigate has not been explicitly taken away. So presumably, Millard, it's not exclusive. Millard would take the original notification first at page 30.
Yes.
The Special Task Force of West Bengal so created will deal with various nature of offences like.
No, what about the second one? Let us see. Oh, second one is yes.
Offences to be investigated. But it does not confer any exclusivity probably.
No, but then it says FIR has to be lodged there also.
Yes. To enable STF West Bengal to register FIRs. So in a particular reported crime, if they want to investigate, it is a wide prerogative granted to them.
But then by that logic, the jurisdiction of the local police stations and the courts are not taken away by this.
Not taken away exclusively.
So then those jurisdictions remain.
Those jurisdictions
But it depends on the whims of the state.
Whims of the STF to take over any investigation and carry it with them.
It's a parallel jurisdiction which is
parallel jurisdiction which according to us, Millard, is a essentially legislative function which cannot be done by way of executive notification.
Special task force, there is no part to creating a special task force as such, because
Milord,
STFs are created.
Milord, in the
But-
original writ petition, which we moved before the honorable single judge, we did not challenge the constitution of the STF as such. The FIR, that notification and the subsequent conferring of jurisdiction of the court. These are the two notifications we challenge. But since now your lordship is hearing a
STF,
PIL.
why can't a special task force be created on a case-to-case basis?
Without a statute, probably it cannot be. Without a statute, it always can be, but without a
What do you
statute, it
mean by a
cannot be.
special task force? A particular,
A force within the force.
it's a permanent force.
It's a permanent force.
not
They
a-
have a permanent headquarters. they
Not
have
a
permanent-
one-time thing.
Not a one-time thing. That is SIT, Special Investigation Team, which the court constitutes, which in a particular sensitive crime, the state can always have the prerogative to constitute. But you are constituting a force within a force, you are citing two provisions of law. But the said two provisions I have shown to your lordship cannot at any stretch of imagination can be read as an
Two
enabling
provisions of the
provision.
BNSS have been referred to you, and
Yes, this is the provision for creation of police station.
and
Maybe kindly take that one.
113 something was also mentioned somewhere.
First, Milord takes 2U of the BNSS. Police station means any post or place declared generally or specially by the state government to be a police station and includes any local area specified by the state government in this behalf. So, specially, one example is the woman police station. Every district is having one.
Yes.
It's a special police station. Now, where a police station is already in place, can a further police station be created only for the purpose of lodging FIR and for the purpose of carrying out investigation subsequent thereto, Milord? This is something, Milord, which I cannot.
Suppose let us take their argument, their best argument. Now,
Yes.
why is this not a police station? Why is this not a post or place declared generally or specially by the state government to be a police station, and including any local area specified by the state government? So the state government can include any local area and confer it to a particular police station, which has been done here.
Yes, but for the purpose of investigation. That's what the notification says. Now, so far as the
FIR,
purpose of investigation is concerned.
FIR also, FIR also.
FIR also, for the purpose of investigation,
Hmm.
FIR is, Milord, the prelude to an investigation.
Hmm.
Now, if Milord consider section 175 of the BNSS, it's absolutely contrary to that. An offense which has happened in Kuch Bihar, Alipurduar, Dinajpur, Darjeeling, Kalimpong, FIR cannot at any stage of imagination be.
We were also on the constitution of the STF. I
Yes,
mean,
we are also on that.
a special police STF can be created under 2U. Why not? I mean, they say it's a police station. It's a post or place declared generally, but
Yes.
it's a force being created.
It's a force being created.
Not a police station.
First a force, then they create two separate police stations for that force. STF police station Siliguri, STF police station Bidhannagar.
But they can't they create police stations? And suppose theoretically, I mean, apart from the other aspect of it, that it would be very inconvenient.
Law does not permit.
No,
In
this
that event, Milord, kindly assume, in that event, ED can have a police station, CBI can have a police station, SSB can have a police station. Once a particular local area is already included in a police station, notified under section 2U, there is no further scope to create a further police
no,
station.
just clarify us on this, Mr. Ghosh. 2U includes any local area specified by the state government in this behalf. So the state government theoretically
Yes,
can say that entire North Bengal will come under this police station, and entire South Bengal will come under another police station.
yes, it can. Up till the act of notification, probably theoretically there is no difficulty.
So they can create a police station.
Yes, but once you tag trial and investigation with that police station, the problem starts. That goes contrary to the BNSS. Theoretically, you can.
But
Probably you can.
what will be the job of a police station if we are arguing against you, so that you can
Yes.
understand. What will be the job of a police station unless they can register FIRs and I mean, investigate?
That's where I am, Milord.
So theoretically, why can't the court? Theoretically, we are saying because it's very inconvenient, it's obvious. I
Yes.
mean, we'll also look into that aspect. In appeal, we can look into that aspect also.
Yes.
Whether that violates basic
Absolutely.
rights of a person.
Once a police station is already
Access
in
to
place-
justice, whether that is affected, we can look into that. Access to justice is a part of
anything. Now,
21
Millard's
also.
hands are very wide now.
Will-
Millard can
yes.
go to any extent. Now, Millard.
But
one thing-
theoretically, they can say, Mr. Ghosh, that this particular police station will deal with entire North Bengal and that will deal with entire South Bengal.
But when there is already a police station in existence, can they do it? The ordinarily.
This is the first creation. The first creation, that creation is already there. There are
Yes,
police stations.
yes. Already, any area Millard is already included in
Alright.
the police
There
station.
will be an overlap.
There will
And
be an
that
overlap.
will be at their choice.
Yes. Now, you have created these two police stations. Theoretically, I assume you can. You have done it very well. Now, can you tag the police station or use a threat to tie the courts with the police station using this? What you cannot do directly, you cannot do indirectly also, Millard. And ousting.
And if you
conferring,
come back to
taking away-
175, Mr. Ghosh,
Yes, Millard.
175 says, we skip the first part, any officer in charge, etc., investigates
Yes.
any which a court having jurisdiction over the local area within the limits of such station would have power to inquire.
Correct.
So therefore,
Therefore,
right,
the principles of chapter 14 also guides the principles of circumscribing the jurisdiction to investigate.
it comes down from the court. Comes
Right.
down from the court.
It's connected with the court
Because if it's the
jurisdiction.
court of the local area within the limits of such station, but here it states which a court having jurisdiction over the local area with, it does not stop there. Within the limits of such station,
Within the limits of such station would have power to inquire and try under the provisions of chapter 14.
so it has to be the local area cannot be changed. Local area remains the local area. The word local is local. I mean,
Yes, it's literally local.
literally local.
Because the fundamental thread of jurisdiction in criminal law is the principle of territoriality.
Yes, and it local means it's bound to the location.
Location. It's always the local, the first provision of chapter 14 I have shown, ordinarily.
All right. And they have referred to something else also apart from 222, 22U, 113 or something we saw somewhere. That's just. Before they spring a surprise on you, Mr. Chaudhary springs a surprise on you. We want to look into that. No, maybe my mistake.
Millard, maybe it has skipped my eyes, but I am going through again, Millard.
I saw somewhere, I mean, maybe somewhere else. I mean.
Offenses, man.
Oh, yes.
Offenses under chapter so and so of the,
Right, right.
that so and so.
So let us once look at just section 113. We'll get an idea of what they're trying to drive at.
Chapter 7, 10 and section 130.
Measuring where against the union government.
Those are of the same nature as the others. So put these, the special acts basically.
Yes,
These are the special acts.
The
all the
special acts.
Specialized crimes for.
Special acts, offenses of graver nature.
So they create a special task force for these special acts.
Correct.
I mean,
Special task force for the special acts. Probably there is no difficulty if they can do it
You
by
are
way of a
thinking that-
statute. They should have done it with a statute according to me.
they could not.
Second,
The legislature could.
the legislature.
They are not the legislature,
They are
which we
not the
forget
legislature.
often
Yes.
nowadays.
Yes,
Yes. Due to the acts of both the wings, other wings, both the other wings.
correct, absolutely right. Second, creation of the FIR, then tagging the courts with the FIR, thereby ousting the jurisdiction of the ordinary criminal courts. So these are the three legs. Now, Millard, I'll just make one argument. Whenever you are ousting jurisdiction of a criminal court or conferring jurisdiction upon a particular court, which you have done here, it's constitution of a court, of a kind of a special court. Now, so far as Millard, our system of law is concerned, this can be done only by two ways, either by way of constitution or by way of designation. There is no third way you can do it. Constitution means by way of a legislation, you have to constitute a special court. I'll give your lordship two examples of this. I'll show just two acts. And second, if you have to do this, you have to, by way of a legislation again, you have to designate an existing court to be empowered to exercise a particular jurisdiction. Except these two ways you can.
In this Commercial Courts Act,
It's an act. It's
but
an act.
the
It's a
act
constitution.
provides that.
It's constitution.
Act provides that the state shall
Constitution.
designate the courts. Yes.
Constitution. The second way is designation.
None of these acts do so. I
Do-
mean,
do
They have
so.
not referred
No,
to these
no.
acts at all.
Nothing, by way of executive notification. NIA or-
Yes, yes.
The example of constitution,
Hmm.
I'll just show one example, there are many. The NIA Act.
Commercial acte পাওয়ার দেওয়া আছে স্টেটকে করার সেটা ইনভোক করে যদি করে আলাদা কোর্টকে তো টাচই করতে লাস্টেরটা তো একেবারেই করে না প্লাস অ্যাপারেন্টলি সাবজেক্ট টু হোয়াট দে সেড আর প্লাস টাস্ক ফোর্স কেস টু কেস বেসিস একটা টাস্ক ফোর্স না না অসম্ভব একটা মালদার লোক তার মানে হ্যাঁ ভাবতে পারেন আমার এখানে অফেন্স হলো আমি চোখের সামনে একটা অফেন্স দেখছি এই একটা নার্কোটিক ড্রাগে আমাকে যেতে হবে পূর্ব মেদিনীপুর থেকে নবান্ন যেতে হবে নবদ্বীপে তো না নবদ্বীপ
I have a printout also for the একটা printout দিয়ে দিন।
তাও ভালো
আচ্ছা,
নবদ্বীপ করেছি নবান্ন ভালো
Yes, section 11. Power of central government to constitute special courts.
দেখেছি দুটো কপি দিয়েছি আপনি মার্ক করতে চলুন ইয়েস
The central government shall, by notification in the official gazette for the trial of scheduled offences, constitute one or more special courts for such area or areas, or for such case or class or group of cases as may be specified in the notification. So this is one example of constitution, which Millard would similarly find under the Prevention of Money Laundering Act. It's a constitution with consultation with the High Court, if Millard recalls that provision. And Millard, I'll give your lordship one other example of designation. That is also another way of creating a court, which Millard would find under the POXO Act. Section 28. Where the marginal note is indicative. Designation of special courts. For the purposes of providing a speedy trial, the objective is clear. The state government shall, in consultation with the Chief Justice of the High Court, in all cases of designation, we would find consultation is provided in the Act. By notification in the official gazette, designate for each district a court of session to be a special court to try the offences under that.
which is actually done
Which is actually done. This kind of examples, the SC/ST's Atrocities Act, there are many acts Miller knows. Now, Millard, one curious case is the MPs and MLAs special court, which was created by a judgment of the Honorable Supreme Court. Now, once the Supreme Court directed creation of those special courts,
141 article 141 that
Right.
becomes the law
right, now Millard, there is a further development to it. The 3 judges committee of the criminal laws in the Madras High Court raised an objection that this cannot be done by way of a judgment. It has always by way of a legislation. The Honorable Supreme Court has took up this in a review petition. I will place the order which has been passed. It is probably not finally disposed of. Why the Supreme Court has clarified, yes, we have directed, but it cannot go against the CRPC. Okay.
Reported.
না না আনরিপোর্টেড ওটা 4 কপি আছে অনেক কপি আছে
আসলে কোনো সব এই মামলাগুলো করে
Millard, para 8 internal page 12.
it was during justice raman na
Millard, it's probably a 3 judge bench probably
yes yes
subject to correction. Honorable the Chief Justice, Justice Chandrachud and Justice Suryakant. The internal page 12, paragraph 7. The order of this court dated 4th December 2018 makes it abundantly clear that instead of designating one sessions court and one magisterial court in each district, the high courts were requested to assign and allocated criminal cases involving former sitting legislature to any sessions magistrate as each high court would consider. The above directions do not mandate the high court to transfer cases which are triable by magistrate to sessions court. The directions contain in the order dated 4 December 2018 do not supplant the jurisdictional provisions contained either in the Code of Criminal Procedure 1973 or in any other special enactments governing the trial of offences governed by those enactments. So, this further clarifies the position that even under 142, the Supreme Court expresses doubt whether by way of exercising powers under 142,
141.
the 141, we can create a court or not. And probably the answer is very clear. That is chapter 14.
Yes.
And so at this stage, Millard,
There are courts in place now which have territorial jurisdiction over these
Absolutely.
offences.
Absolutely.
Right.
And there is no object disclosed in either of these notifications. What is the compelling circumstances which are prompting you to take this action? I have some judgments before this bench, at least I
No,
do
no,
not refer
to-
that, at
on-
least at this stage,
On what proposition?
that conferring or taking away of jurisdiction of a court is essentially a legislative function. It can neither be delegated nor it can be taken away by anything. It's a legislative power to be exercised by the legislature.
Good.
I'll just point out the relevant entries in Schedule 7 to the Constitution. Millard knows. Just Millard, the provisions in which Millard all those enactments are being done. Millard would kindly mark Millard the legislative power of the state. Millard under Schedule 7, Millard, the list 2, the state list. Millard, I am specifically referring to entry 65.
Just read it out.
Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in the list. And 1 and 2 deals with public order and police. So if you align this, that the objective was something connected with public order or police, even then the legislative power is granted under entry 65 to tinker with the jurisdiction of the courts, and that is essentially a legislative power. That's why I'm not burdening at this stage
No, no.
with the
let us say-
judgments.
Yes.
If required, Millard, I will.
Yes, Mr.
Millard, before Mr. Chaudhary takes over, Millard, one provision I forgot, Millard, which I had to place, Millard. Millard, section 208. Millard, that might look like an exception to this, but which is actually not.
It is outside
No,
India.
no, Millard, I'll just place. Chapter 14.
200 outside India often.
That's it. No, no, he's meaning something else.
Yes.
So 205, sorry.
Different session.
Yes,
Power to order cases to be tried in different sessions divisions.
yes,
Notwithstanding anything contained in the preceding provisions of this chapter, the state government may direct that any case or class of cases committed for trial in any district may be tried in any sessions division, provided that such direction is not repugnant to any direction previously issued by the High Court or the Supreme Court under the Constitution or under the Samhita or any other law for the time being in force. So state has a power, but this power becomes operative only post taking cognizance for the purpose of trial, and it cannot be contrary to any other law in force. So even then you cannot skip the general provision of chapter 50.
and you can also look at section 5111.
Yes,
There
the
are
saving clause probably will have to
no, not there. Just come there. But that also pertains to post facto finding of sentence.
Yes, yes, yes.
Because in a PMLA case in Calcutta, it came up. A question was raised by
Right.
the Additional Solicitor General of India, Mr. Raju. And it was argued that 223(2), that prior right of hearing, precognizance right of hearing, which has been introduced by the BNSS. So whether that circumscribes to 210 cognizance and how far, and an argument was raised by the state there that state means the union that no, This 511 is there. Therefore, for territoriality, it cannot go. Therefore, for a technical reason, it cannot go. That which was turned down by us by saying that
Right.
no, this is not regarding territoriality. It's a right, audio alternate partem, and other things.
Correct.
So 511 also may come in, but all are post facto.
All are post.
So that is an indication as to the intention of the legislator
Correct.
also probably.
To save and protect exceptional cases. What
One
if
is
it's already taken.
205, 511. What is the other exception you pointed out?
Pillar 205. And below to
No, the
the
previously
general exceptions created under chapter 40.
chapter 14, yes.
But that has no application because that relates to cases like kidnapping where the offender is found in a different jurisdiction. Probably that court has
That is
jurisdiction.
somewhat different. Yes.
That is something.
Right. So let us,
That's all as of now.
let us have it. Yes, Mr. Chaudhary. You are challenging which of the all these three notifications?
No,
Last
as of now, Millard,
Courts.
creation of the
Courts.
police station and the court.
Which
That is
pages?
Millard, page 55 and page 57.
56.
57. Page 57.
Oh.
And Millard would recall, Millard, yesterday when briefly your lordship took this matter, Mr. Sarkar submitted that Ms. Sarkar submitted that they have already started registering cases.
Yes, that was the urgency you said.
Yes.
Already, yeah. So, my lord, basically, my lord, this is the lead petition. Thereafter, my lord, I converted into a PI. Now, my lord, the grievances which my learned friend said is started from traveling from page 55 and ended with a 57. So, my lord, the STF
Yes.
has constituted a special task force under the provision of 2 acts, my lord.
It has not actually been converted to a PL. The Chief Justice's order says, considering the wider the learned peruse the order of Justice Bhattacharya will read it out to you.
Yes,
Both of
yes.
you are required to know that. The learned members of the bar are the writ petitioners wherein challenge has been made to, this is the Chief Justice,
Yes.
where a challenge has been made to a notification conferring power on a particular court to consider cases where investigation is being done by the special force. Considering the wider ramifications that may arise, the writ petition shall be heard by the regular division bench in the circuit bench at Jalpaiguri, and it may not be required to be treated as a public interest litigation. So if it's public interest litigation, the Jalpaiguri circuit bench rules say that public interest litigation we don't have. So that's why it's not treated as a public interest litigation, but heard by a division bench because.
My lord, but if you lordship see the.
But any event, we'll look into all the facets of the matter since it has been assigned.
If you see the learned, my lord, the trial judge, a single bench's order, my lord. These they were referred to the Honorable Chief Justice, treating this.
No, that has merged with the Chief Justice.
Yes, yes, and the Honorable Chief Justice, my lord, has this the administrative order.
Says not a pill, but wider ramification, division bench.
So,
The bit has some context, so let us hear it. Yes, what is your?
so we are not going, my lord.
No,
So-
we are not
so-
going.
So, my lord, maybe as a PIL, we have division bench, or maybe.
Your argument should be on the footing of a PIL because of the wider ramifications.
Yes, this is if the wider
Chief
ramification.
has just
The wider ramification has thrown a light.
dumped into it
But
on us.
thrown a light.
Yes.
Definitely, Lord, it would be a PIL.
Yes, Mr. Chaudhary, be quick. We'll have to leave our officers today. They have their trains.
I'll be very
Be precise.
my lord. My lord, now this challenge, particularly the writ petition, is 55. Now, my lord, kindly turn down 55, which lordship has seen even. Now, my lord, in 2019 already, my lord, give me a little background. 2019, my lord, the STF was constituted, my lord. The special task force designated and trained forces to undertake certain criminal offences so that investigation can be carried out properly. So, 2019, it was functioning. Kindly look back the 2019 notification. Page 30, Page 30, is a notification of 2019. Now, the second paragraph, you lordship kindly see, there will be a 5 offices headed by the deputy SP rank officers at Kolkata, Siliguri, Malda, Durgapur and Kharagpur. So these are the offices, and hidden by the officers or the staff. Now, the next third paragraph, the STF branch at Siliguri will be headed by the SP rank who will supervise Malda unit. So Siliguri office was given to charge of Malda unit to extend. units of Durgapur and Kharagpur will be supervised by the headquarter at Kolkata, and Kolkata itself a Kolkata. So it is on Milord, and the special task for West Bengal Police so created will deal the various nature of offences 1 to 8. Now, Milord, 2019, the moment the STF Milord started functioning, the difficulties what the STF faced. Milord, the moment the STF register or Milord, there is offences, then has to be registered before the local police station. And the moment it has been registered by the local police station, then by the superior orders, Milord, that has to be transferred to the Milord, to the STF to undertake or Milord commensurate the investigation in light of that. Now, Milord, with suppose Milord, an investigation, suppose now Milord, a local police offence committed at Alipurduar district, suppose for in North Bengal particularly. Then Milord, the offence or the registration affair should be an Alipurduar PS. Then it would be handed over to the Siliguri having the local jurisdiction to undertake this type of offences. If the STF are investigating, these are the offences. Then Milord, by this time of 2-3 days Milord, before registration and handing over to the STF, then Milord, the vital evidences are Milord, we are not in a position to find out, or the Milord, even the accused could not be apprehended and they may have fled away. This is the reason Milord, from 2019 to 25 Milord, before this police station has been created, these are the Milord, the difficulties predicament was facing by the Milord STF. Keeping in mind now, Milord, kindly turn down page 55. Now, page 55, Milord.
55.
Now the Milord, the provision, the what is the gazette, by a gazette notification, the power exercised by Milord, the clause section 2 of subclause U, Milord. Now, Milord, your Lordship has read, Milord, kindly read once more, Milord, to you.
One thing, Mr. Ghosh, if you're not challenging page 56, then the registration of the FIR still has to go there. It will be a truncated challenge then.
No, if the constitution of the police station itself is what we are challenging, so there's no question of filing of FIR. There are already police stations who are
No,
filing
it's
FIR.
this says purposes of investigation.
Yes, and the second is for the purpose of registering of FIRs, enabling FIRs.
All right.
So
Get your
that
point.
is consequential probably.
Get your,
Let's
get
subject to
your,
that.
get your point. Yes.
Now,
Yes,
Milord,
Mr. Ajit,
yes,
sorry.
Milord, kindly come, Milord, to you. So, Milord, by your gazette notification, Milord, what government has done, 2 police stations have been created. Milord, 2U has given a power. The police station means any post or place declared. Milord, kindly mark the what the place declared generally or specially by the state government to be a police station, and includes any local area specified by the state government in this behalf. So, exercising the power of 2U, Milord, 2 police stations have been created. Milord, I would like to clarify also, the exclusive jurisdiction was not given to the STF. This is in addition to the jurisdiction of the local polices having the territorial jurisdiction, and automatically the court has the jurisdiction within the local limits if the investigation or the FIR has been registered.
So, Chudi, there's one difficulty on you relying on 2U for
Yes.
this page 55 notification.
Yes.
Now, as per the scheme of section 22U, the post or place which is declared to be a police station has to follow the locality, the local area, not the other way around.
Yes.
You cannot say, I create a post in X place, or I choose a post or place in an X place, and say that the local area will be this local area. Here it says the post has to follow the local area. In that particular local area, you can designate a particular post or a place, yes, like outposts or police stations.
But it,
Because we're telling you why. Police station means any post or place declared generally or specially by the state government
yes.
to be a police station.
Yes.
This is first limb.
First limb.
Second limb is, and includes any local area specified by the state government in this.
Behalf.
So the state government can specify a local area. This is the local area,
Yes.
and this post or place is declared to be a police station in that area.
Yes.
So the post or police station has to be in that local area.
No, my lord, kindly.
Because otherwise the entire scheme of 197 and the other
My
provisions
lord,
will
I am
go.
coming, no, my lord, 197 will not go. My lord, that I am coming later part. The moment the conferring the jurisdiction to the court, my lord, that I am coming.
Local area has a meaning.
Yes.
Then it would be only area.
Yes.
Then for a particular area, this would be means any post or place declared generally or specially by the state government to be a police station and includes any area specified by the state government in this behalf.
Yes, my lord.
That's the huge difference between a local area and an area. Now, if this was only area, Mr. Chaudhary, this challenge would fail because then the police station may mean any post or place declared by the state government to be a police station includes any area specified by the state government. But once you say it's a local area, it has to be tied to that local area.
My lord, the local area specified by the state government.
The local area,
My lord, kindly
the police
see the-
station of Calcutta cannot be the local area police station of Calcutta cannot be situated in Bombay.
My lord, kindly
If
read.
it's a union government, it's a union, it's a central act offense. Then what the government will do is the union government can tomorrow say, if an offense under that central act has been committed in Calcutta, you have to go to Jammu and Kashmir and register an FIR.
So that is to, my lord, because
That is, if you take this logic to its
within
logical
the-
culmination,
no, my lord, within the state. Within the state.
that is what we are saying.
My lord, kindly
In the
read-
central acts,
Yes.
if it's the central territory like CBI or something like that,
Yes.
then it can be said tomorrow, court, the union government may say, no, we will do this. We will designate Bombay for registration of FIR for Calcutta offense. It's like that. It's not that much. But yes, suppose something happens in Murshidabad, one has to go to Salt Lake.
It is not a, my lord, it is not, it is a, my lord, the
Then the
jurisdiction-
creation of the circuit benches are
my lord,
meaningless.
the jurisdiction has not been taken back away. Here in the establishment of circuit bench.
More serious thing has been done. It
Well,
gives a choice entirely on the state because these are offenses where state has a huge role to play.
Yes.
And if you see 90% of these cases,
Yes.
the investigations are handed over to either CBI or to at least to CID. If you see, if you just look at the
Yes,
laws.
yes.
So this correlation is very disturbing to us, Mr. Chaudhary.
No, my lord, if it
This
is-
correlation
if
is
it
very disturbing.
My lord, if it is within the scope and ambit of the, my lord, act or the statute, then, my lord, you have lordship can correlate. Can you read N once, my lord, 2N?
Yes. In
Local jurisdiction in relation to a court or magistrate means the local area within which the court or magistrate may exercise all or any of its powers under the Sanhita. And such local area may comprise the whole of the state or any part of the state as the state government by notification specified.
yes.
So, my lord, the N and if your lordship, this U, if your lordship correlate,
Read together. Yes.
yes, conjunctively, then lordship kindly see the second leave as lordship said, includes any local area
Hmm.
specified by the state government in this behalf.
Hmm.
So state government has specified this is the local area having the jurisdiction of these two police stations to try to investigate, to cause an investigation with a certain offenses.
Hmm.
So, my lord, the 2U, the power given by the Sanhita.
All right.
Then, my lord, the next page, next 57, my lord, is conferring, my lord, the powers to the courts. Now, my lord, because my learned friend, what he said, it has not come up with a gazette notification, my lord. By a gazette notification, it has come conferring the, my lord, the powers to the courts local limits to be tried by these offences. My lord, so, my lord, this, may I hand over these 2-3 documents, my lord? Now, before, my lord, the page 57, my lord, kindly come, my lord, my document which I have handed over. Page 3, my lord.
Yes.
1 and 2, that STF notification, page 3.
Right.
Page 3, my lord, it is a 5th June 2024. My lord, there was a, my lord, the communication between the, my lord, the Principal Secretary Judicial Department and the other government department.
Hmm.
Malad, here there was two information was sought for. Malad, if your lordship see the reference, the honorable court's letter number, the high court's reference number, letter dated such and such, and the two others communication, then furnish the number of cases which are pending registered in respect of STF headquarter and STF Siliguri PS. This one information. Second, furnish a copy of resolution of 17 March 2020 at the meeting with the judicial secretary and the law secretary, West Bengal at earliest convenience. Then below the kindly turn the next page, page 4. Is at 12/11/2024. Milord, there was a
Why you are
proposal,
placing this? Why you are placing this?
Milord, for the conferring the power to these two courts. One is in Vidhannagar court, one
Yes.
is in Siliguri.
Right.
Page 57. So these are the before these 57.
Hmm.
These are the notification has come that I am preparing.
So those have been gazette notified.
Yes, later on, but I'm showing that.
No, if you say we'll take that on face value, show us the gazette notified. Why
Yes,
do you
Milord.
go into your internal communication?
Then straight away come the page 5, and then thereafter the page 7. No, 13 is a later part. Then kindly straight away come to
13 is the gazette notification.
Gazette notification.
So it's gazette notified. Mr.
Yes.
Ghosh said he does not know. I am not aware.
I said it was not in public domain. We didn't have access.
Yes. So both are gazette notified. We
So
get,
gazette
take that.
Now,
Yes.
kindly see
Hmm.
the paragraph 2 and whereas.
Yes.
A reference was made to the judicial department and the state government for bringing the newly created two STA police station under the respective jurisdiction of criminal court for trial of the offender. And whereas judicial department of the state government, by letter number so and so dated 8/4/2025, has informed the Honorable High Court Calcutta has been pleased to assign the jurisdiction of criminal courts in respect of the newly created STF headquarter police station and STF Siliguri police station for trial of offences. So, Milord, it is not a special court. So, Milord, the special court, as the NI Act was placed before your lordship, is a special court was established under the statute.
Hmm.
Now, Milord, the enabling provision, Milord, kindly come to first 2N, Milord, which I have reliance, Milord, 2N.
Hmm.
Then, Milord, kindly come to section 6.
Yes.
Section 6, Milord, the cases of the criminal courts, Milord. Here the
Classes.
courts classes. Then, Milord, next section 7 is a territorial division. Milord, the 7(1). Every state shall be a session division or shall consist of sessions division, and every session division shall, for the purpose of the Sanhita, be a district or consist of districts. Milord, kindly consist of districts. Then, Milord, 2. The state government may, after consultation of the High Court, alter the limits of the or the number of such division and districts. Then 3, Milord, the state government may, after consultation of the High Court, divide any district into subdivisions.
Nothing of this sort has been done by you.
Milord,
This has not been done by you by the impugned action.
this is the Milord, with the consultation of the High Court. The
You have
criminal
not created a separate sessions division or something like that.
the power was given to these two courts.
It's not exclusive power. This is an exclusive creation of power. The sessions, divisions, districts, and subdivisions existing as state shall be deemed to have been formed. Yes. This is something else. You have not done this.
This subject, sorry for the interjection. Say Alipurduar is carved out of Jalpaiguri. A new sessions court is created in Alipurduar.
Yes, that like delimitation in case of
It
elections.
is a jurisdiction.
This is equivalent to delimitation in.
Geographical bifurcation.
No, Milord, as of now,
This does not apply here.
no, Milord, if the gazette notification, Milord, as said, gazette notification with the consultation of the High Court, we have done this. Now, what is the proposal?
No, consultation of the Chief Justice has given.
Yes, Milord. It is given.
But-
Milord,
but-
gazette notification, Lordship, kindly see. Third paragraph. And whereas the judicial department of the state government, such and such, has informed the Honorable High Court Calcutta has been pleased to assign the jurisdiction of criminal courts in respect of newly created STF High Court, Police Station.
Where is that
STF
High Court communication? Do you have it?
Milord, that Milord I was looking for
You could not find it.
yesterday, Milord.
No,
Judicial
maybe,
Secretary-
may or may not. Yes.
No, no, Milord, we have, but because of the paucity of time, Milord, I
Right,
could not
you
bring
could
it.
not. Maybe.
Milord, these are the, that's why I said the internal, before the gazette
But this,
notification.
how does this come under section 7? We fail to understand. This is not a territorial division.
Milord, then,
Territorial division is every state side. This is a creation of territorial division of sessions division. What are the territories of the sessions? That still remains unchanged. The sessions which were there are still in force.
the additional, this is the limits, Milord, that additional power was given to that. Then definitely, Milord, we have to look into the communications, under which provision the Honorable High Court has assigned the jurisdiction or conferred the jurisdiction to these two courts.
What is the order of the High Court?
Order of the High Court, Milord, this is the reason, Milord, I was trying to, Milord, place 2-3 reliances, Milord. But, Milord, if your Lordship kindly come, page 9. But High Court's communication, Milord,
How can the High Court confer power?
Yes.
Courts cannot, it's settled that courts cannot confer jurisdiction which is not there.
Yes. But the Honorable High Court has conferred this power.
It itself does not have the power.
Not it still has not the power, then
Under
definitely
which law does the High Court have the
then
power?
then the High Court ought to have been made a party, Milord. The High Court should clarify it, under which provisions the High Court has conferred this power.
You are failing to produce even the order.
Milord, yesterday matter was made.
You have not referred to a specific order in this.
No,
You merely say Honorable High Court has been pleased to assign the jurisdiction.
exactly.
Where-
This
where do you get it?
internal communication.
Gazette notification says that.
Yes, gazette notification say.
It should just take the trouble of referring to a particular date of order or the matter in which it was done.
Milord, it was the gazette notification. Definitely, it has come before that internal communications, notifications.
Everything has been mentioned
Yes.
and government later details are mentioned. You just omit to mention the gazette notification by which order in which matter High Court has been pleased. In every matter, even in a legislation when it is done, Mr. Chaudhary, it's well settled that the exact order and the writ petition number, even in communications to us by which several things are being done.
Yes, Milord.
Now, even the death reference we are taking up by directions of the Supreme Court, in every communication, the particular date of the order and the number of the matter is given.
Yes, Milord.
And it's absent in the gazette notification. High
Milord,
Court, we cannot just please, I sit in my chamber and say, Mr. Chaudhary, please create this.
No.
We are not
No, definitely-
Nawabs.
Definitely, it has not been in that fashion. It has
So
not.
then
been.
you have to refer to that order. The High Court, Honorable High Court is a general body.
Yes.
Has been pleased to assign the jurisdiction. How can it assign? We do not have power to assign jurisdiction to any criminal court, Mr. Chaudhary, under any law.
Milord, if you Lordship see the reference of 8 April 2025 with the gazette notification, kindly come page 11. That letter was forwarded to the Milord, the Honorable High Court, Calcutta, page 11. In the notification letter dated 8/4/2025.
Here also you say the same thing without referring to any order.
No, that was Milord referred to the Honorable High Court, Calcutta.
Copy for what was the
That was referred to the Honorable High Court.
what was the reply of the High Court?
Milord, that definitely the reply of the High Court, but at this
Only
juncture-
apart from that, everything else is present, Mr. Chaudhary. Isn't it surprising? High Court's order could have been only a note of exclamation
Milord,
or a
Milord,
question mark,
Exactly. Milord.
like GBS.
Milord, the High Court's communications, Milord, definitely, Milord, if a Lordship kindly keep it Monday, I will place it the High Court's communication.
Monday
Because
will
Milord,
have
at 9. Because
then it has to be kept in some cafe or some restaurant in
No, it should
some
not
good
be.
place. Monday, if you could,
Monday, Milord, kindly see, it was posted yesterday under the getting out to be mentioned. My junior has sought for a time. Then, Milord,
it should have been prepared when it went before the learned single judge itself.
Milord, when it was when.
So
the
a writ
preliminary-
petition copy was given.
Yes.
That writ petition came up before a learned single judge. You
Yes.
would not be ready with that from then.
That time
You knew the single judge referred it to the High Court.
That time, our limited points was that it is the nature of the PIL. So the single judge has no jurisdiction or determination. With that score, Milord, the documents was forwarded to us. And Milord, now with the data ramification, Milord, now I have a challenge that whether this application can be entertained or not, Milord.
Why do you
I
say
have
that,
a-
Mr. Chaudhary?
Yes, Milord. But only one judgment I will rely on, is the 2010 3 SCC 402. State of Uttaranchal, Balwan Singh.
Yes.
If your lordship see
2010 3 SCC 402. 2010 3 SCC 402. Yes.
kindly see the from the paragraph. Just I am just head note only. I am just relying the A head note A. The paragraph 1, 2, 3, 4, 5 allowing starts from allowing. From that page, first page. Head note A, first paragraph, second, third, fourth, fifth paragraph. Allowing the
Acha. Held.
allowing the appeal
Yes.
and imposing costs such and such held. The court must encourage genuine and bona fide PIL and effectively discourage and club PIL fixed for extraneous consideration. Instead of every individual judge devising his own procedure for dealing with PIL, it is appropriate for each High Court to properly formulate rules for encouraging genuine PIL and discouraging PIL filed with oblique motive. The High Courts which have not yet framed the rules should do so within 3 months. There is the chain of the High Courts. Now, 3.
We don't have any such rule as for our.
As of now. Well, I'm not there. And the copy of the rules prepared High Court be sent to the Secretary General. That was the direction. Then, my lord, 3. The court should prima facie verify the credential of the petitioner before entertaining appeal.
People who are representing the litigants every day, what better credentials can then that there be?
I'm coming, kindly read 7. Then straightway come to clause 7.
Yes.
The courts before entertaining PIL should ensure that PIL is aimed at redress of genuine public harm or public injury. The court should also ensure there is no personal gain, private motive or oblique motive. Kindly read paragraph 2.
Yes.
Read petition. Read petition. Paragraph 2, Lordship.
Yes.
The petitioners herein are regular legal practitioners before the district and sessions court and the trial courts in Jalpaiguri, especially on the criminal side. The scope and purport of the impugned notification and subsequent communication directly infringes upon the powers and jurisdiction of criminal courts functioning in Jalpaiguri and resultantly affect the scope of profession of the petitioners herein as well as other legal practitioners who are practicing in courts of Jalpaiguri dealing with the criminal matter. Then, my lord, the
Personal gain angle comes.
personal gain, 22, paragraph 22.
Yes.
The petitioners submit that in the event such proposal is being such and such implemented, number of criminal cases pending before the competent criminal courts at Jalpaiguri is likely to
Come to accordingly, direct.
accordingly, as a result thereof, my lord. As a result thereof, the number of cases which the petitioner could have dealt
Next sentence. Next
shall
sentence.
be substantially reduced.
Next sentence. Accordingly.
Since several special acts dealing with the criminal cases have been included under the scope and purport of the impugned notification.
No, accordingly. It shall be needless to mention. That is the only paragraph which catches our eyes.
Paragraph 22, my lord.
Right in the middle of paragraph 22.
Accordingly, it shall be needless to mention the professional prospects of the petitioners as well as other legal practitioners shall be substantially affected and the said proposal thereby directly and proximately infringes the right of the petitioner to carry out the provision of the court, Jalpaiguri as well as the district courts. So, my lord, if your lordship see the first entertaining this application with the wider ramification, my lord.
Yes. We'll use this tag for you and the pink so that you can easily remember.
Green, no.
Green for the state.
Green.
Pink for the yes.
It could have been blue, Millard.
Is a
Grass is always green on the other side. Yes. And the roots of the grass are of the same color.
the petitioner, my lord, is a bunch of orange or lightly pink.
Pink, we are always in favor of pink. It's a gender issue, yes. Yes.
So, my lord, before entertaining such, my lord, the applications, court has to consider that whether there is the motive.
These are general guidelines. It has been reiterated in every bill.
Yes, my lord.
Public interest litigation, personal interest litigation, propaganda interest litigation, many other terms. Sorry. Obviously, these are guiding principles of PIA.
Exactly, my lord. So, if your lordship see the greater interest of the public,
This is somewhere in between. We are somewhere in between a PIL and a single judge matter.
suppose now, my lord, these courts, these police stations and the conferring the power to the criminal courts. Well, how the people at large would be affected, my lord?
We are telling you why. An offense is committed here. I have to go to Siliguri. If it's not within the territorial jurisdiction of the local police station, Mr. Chaudhary, 99% offenses won't be reported at all.
No, we have
Who
not,
will go to Siliguri?
we have not snatched away.
And snatched
Local-
away. You have
Local police station has.
Murshidabad person, and an offense happens in Murshidabad, under any of these provisions, a narcotics is being carried. Who will go to Salt Lake and complain?
Murshidabad, only if it is apprehended by the Murshidabad police station. Local.
Therefore, the previous system before these notifications was the right system. I lodged the complaint in Murshidabad. Murshidabad court has immediate jurisdiction over it, and either the court or the investigating agency that can be given to the STF. The charge can be given to the STF.
Malad,
That is the right way you are proceeding. But
Malad-
now we have grown wiser.
Malad, the difficulties, Malad, as I have explained, Malad,
You are trying to, as Mr. Ghosh said, tinker with the jurisdiction given in the criminal section 2 N is your best answer. But that has to be have a nexus with the area local. We'll look into that. N is your best argument.
N, and then Malad, with the corroboration of the N.
No, if N comes in your favor,
Ah.
then rest of the local, wherever local is used, that is governed by that circumstance.
Malad, kindly see, if the STF, particularly these cases of the accused has been apprehended by the STF in Jhargram, then only the STF would carry out the investigation.
That is absent from your notification.
No, my lord, that's why in addition to that, the entire power has not been snatched away. The local police jurisdiction and the local courts has the jurisdiction. In addition to that, my lord, the STF has given this power.
You have given jurisdiction. If you please come to this page 57 once.
Lord.
Just come to page 57, Mr. Chaudhary.
Yes.
Now, this is the second paragraph. Starts with now immediately above the chart. Now the aforesaid two STF police stations may be brought under the respective jurisdiction of criminal courts for trial of specific offences as per the proposal below. And criminal courts having jurisdiction have been designated as Bidhannagar and Siliguri. And please come, read with this, please come to page 55 once. Using you have not referred to N, but N is defining provision. The governor is pleased hereby to declare that the places mentioned in the schedule below as special task force police stations and also specify the local areas of the said police stations for the purposes of investigation of the offences mentioned in the said schedule. So can two police stations have territorial jurisdiction over the same area?
Police stations is specified, my lord, from Murshidabad.
You say this is not exclusive.
Yes,
Not exclusive, this is over and above.
No, in the notification.
So
say.
then if that is your argument, then you have not taken away the jurisdiction of the local police station. That was just, then it's a choice of the person complaining either to go to the STF or to go to the local police station.
It is not a choice of the. If, my lord,
It's under this act.
If the STF only apprehends the accused, only
It's
STF.
not stated anywhere.
No, my lord, this is the complete object and motive. My lord, if your lordship, that's why this sudden communication, my lord, I have annexed. The object and purpose was that.
It has to be reflected in the statute. Object and purpose we can look at only if the provision is ambiguous.
But my lord, the purpose is that, my lord, the only STF is the apprehending. Then only, my lord, these cases to
That is absolutely coming from the bar, Mr. Chaudhary. Nothing in any of the notifications.
They got that. My lord, with the instruction, my lord, I am saying.
Your instruction has been given by whom we don't know. He may not be there tomorrow in the post.
Definitely.
You may not be there tomorrow in my place. And I may not be there tomorrow in my
But
place.
it's affidavit, my lord, if something my statement is recorded, my lord.
That would be a dangerous precedent.
My lord, this precedent, my lord, I have obtained an instruction from the appropriate authority, my lord. So without instruction, my lord, I am not. My lord, I have the written instruction, my lord. It's not that I will say on the basis of an oral instruction. I cannot.
Who is the authority?
But at this juncture, my lord, the
Who can
ADJ
who can interpret a government notification? We want to know. We are curious.
my lord, this I have taken the instruction from the judicial secretary.
It can only be the governor, none less. It's under the oath, under the signature of the governor or the governor's office. None else can modify a notification or interpret a notification apart from a court of law.
No, no one can. But below the when this notification has come, before that, below there was a communications. What is the purpose of or the object of or constituting such below the creation of police station? Within the object and purpose that has been specifically created, it is not that any individual they have a local jurisdiction or territorial jurisdiction, and they having the court's jurisdiction, the jurisdictional court has the power to try or to register the offences. This is absolutely not the STF when he is apprehending.
Investigation investigation করতে দিতে পারে এই স্পেশাল অ্যাক্টিভিটিস যদি বলো যে ইনভেস্টিগেশন করবে এই টাস্ক ফোর্স পছন্দ আসছে কিন্তু এই কোর্ট টাই আপ করাটা যেটা আপনি বলছেন আর রেজিস্টার এফআইআরটা ওটার সঙ্গে লিঙ্ক প্রিন্ট করো
STF যে আছে within the force থেকে দিয়ে করছে how the function of STF would be more improved
because at the tying up of the police station with the force. You cannot tie up the police station with the force. Police station has to go with the area, local area, unless it's designated under section 2 N যেটা বলছে হ্যাঁ
how information with respect of
আর সেই পাওয়ারটা থাকছে 2 N কিন্তু অন্য ব্যাপার 2 N যেখানে বলছে লোকাল court or magistrate means the local area which may exist as far as such local area come to the whole of the state or anywhere the state government may by notification specify
for the purpose of court.
Court
is the local area. For that purpose, not for the purpose of police and.
No. No. Yes, anything else, Mr. Chaudhary? Yes.
One the 9 surplus 1. Yes. 9 surplus 1.
9?
9 surplus 1. BNSS.
Yes.
My lord, that is in every district there shall be an established judicial magistrate or the first class. My lord, kindly come the proviso. Provided that the state government may, after consultation with the High Court, establish for any local area one or more special courts of judicial magistrates of the first class or of the second class to try any particular case or particular class of classes, and where any such special court is established, no other court or magistrate has the power. So
we don't find any consultation with the High Court here. Sorry.
That in the notification
Notification does not say there has been a consultation.
does not say.
Notification says that by a direction of the High Court.
The direction or by a letter addressed to the
That is all the more on a lesser footing.
only the assignment of the criminal court jurisdiction. That needs to be to be looked into.
Till that is looked into, don't act on it.
Already, I have said.
We will not put a stay order retrospectively. Whatever has been taken is taken, but from hence till decision, don't.
Kindly appreciate.
Sufficient reasons have been put forward to set aside this by office.
Your lordship pleases to set aside.
No, we are still open. Tell us something which convinces us.
See your consult. Your lordship can put it on Monday. Monday I will place it. Because this is the reason, one day.
Monday, what will you place? That is what you are
The
asking.
High Court's communication. Under which
High
provision?
Court does
Enabling
not have the
provision.
power to create jurisdiction,
Under
Mr.
which enabling definitely High
Under
Court
which,
has, my lord, the Honorable High Court has definitely has passed or communicated some decision. And
this
notice-
decision says even 141, under 141, Supreme Court does not have that power. How can the High Court have power to do it?
my lord, under the BNSS, my lord, as I said, either the division of court or the other class of cases can be, my lord, tried by this. That I said, my lord. Under enabling, under which provision the High Court has passed, that to be looked into, my lord.
So let us hear Mr. Ghosh on 2 to N. Yes, what do you have to say? N circumscribes everything. Why do you say that? Local jurisdiction. দাঁড়াও, একটু বলে।
Local area within which the court or magistrate may exercise all or any of his powers under this Samhita, and such local area may comprise the whole of the state or any part of the state as the state government may by notification specify. So where this power has been invoked? Here
It goes the other way around.
goes the other way around. I understand you want to save something, you are trying to hang on with from something. But in Ambulant 9 has been placed. 9 deals with, say, POXO code. When a special magistrate is created under the POXO Act, no other court will exercise jurisdiction. That's what 9 is. There has to be an act. It's a legislative power. We're going on a fundamentally wrong trajectory. It's a legislative power. No one has jurisdiction. What the High Court, what High Court power? Which power the High Court is exercising? Advisory power, supervisory power, what power? Administrative power. He holds any statute.
Now, if you come to 175, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizance which a court having jurisdiction over the local area within the limits of such station. So, local area within.
Also does not have jurisdiction.
Now, my lord, the state government has the power to define the
And let-
local area
The
under N and U.
Jhargram is a local area of Bidhannagar. If this is Millard, what it is Millard?
Within the state, it has not been specified, not stated that Jhargram has having the jurisdiction.
That's what a notification.
But you have not
says.
invoked N. You have not invoked 2 to N.
That's
So, Chaudhary, that is the difficulty. Your notification also says you have invoked 2 to U. You.
But below the 2U has a consonance with.
2U does not govern the jurisdiction of the court.
No. 2U
You have not invoked 2 to N.
is for establishment of the police station.
They have used.
It cannot be the converse. I mean, the police station cannot determine the jurisdiction of the court.
Then local has been 2N has said, 2N said the local limit the state government may specify.
Creation of the police station, the creation of the police station has been used as a handle to confer jurisdiction. And that's what specifically I have pleaded. What you have cannot do directly, you cannot do indirectly.
দাঁড়া, এখন তুলবো, আমি করে দিচ্ছি। এটা স্ট্রিপ করে দিচ্ছি। আর রেট্রোস্পেক্টিভলি করবো না, বলে দেবো, ক্ল্যারিফাই করে দেবো। Henceforward.
This discrimination angle, what he has said that the local police station's jurisdiction has been not taken away, that leads to a more dangerous discrimination. And extremely, in very strong words, discouraged by the Supreme Court as back as in 1952 in Anwar Ali Sarkar.
That is not a good law, Miller. I knew.
Not a good law because the act has been
Because,
subsequently.
because Miller,
The West Bengal Special Courts Act 1950 has been subsequently.
no, 1917 and 1 SCC Miller, it has clarified, it is not a section 14 is not violated. Miller, kindly say 1979.
Article 14, not violated, read out the relevant portion.
Yes, Miller.
It's not a good law because West Bengal Criminal Courts Act 1950, in terms of which a special court was sought to be created, the court, Miller, kindly see the observations.
We're not going to so much at this stage. We have satisfied you, we have satisfied Mr. Chaudhary, now let us satisfy ourselves.
What I said, Miller, with regards to the communication exchange between the Honorable High Court and the Judicial Department, Miller, that needs to be examined, Miller. So that's why, Miller, unless this we examine even.
We are of the opinion prima facie that no such communication of any High Court has any authority to create confer power under these provisions of law.
Not unless we see, Miller, if the.
We say that in our order. We are bold enough to say that in our order. High Court cannot.
One day.
Mr. Chaudhary, you don't understand. Even if you produce that order, we are saying High Court does not have the jurisdiction. Even if there is an order direction on you, High Court does not have the power. That is what we prima facie feel.
After producing, Miller, Lordship can.
Thank you. We have heard you enough. heard learned counsel for the parties. Full stop. The petitioners are practicing advocates in courts, comma, in and around Shiliguri and Jalpaiguri. Full stop. Next para. The matter went before a learned single judge of this court, who was of the opinion that the matter partakes the character, P-A-R-T-A-K-E-S, the character of a public interest litigation. Push up, the matter was accordingly referred to the Honorable the Chief Justice. Push up, the Honorable the Chief Justice, comma, however, comma, was of the opinion that considering the wider ramifications that may arise in view of the learned members of the bar being the writ petitioners, wherein challenge has been made to a notification conferring power on a particular court to consider cases where investigation is being made by the Special Task Force STF Capital, comma, the writ petition shall be heard by the regular honorable division bench in the circuit bench at Jalpaiguri, and it may not be required to be treated as a public interest litigation. Push up next para. Upon a perusal of the nature of the challenge thrown in the present writ petition, comma, although the Honorable Chief Justice has left it open on us to decide whether this should be treated as a public interest litigation, comma, in view of the observation of the Honorable Chief Justice that it may not be required to be treated so, comma, we proceed on the premise that this is a writ petition, but it has wider ramification, comma, accordingly borrowing some of the characteristics of a public interest ingredient in it. For sub next para, the challenge which has been thrown is primarily to a notification dated February 10, 2025, annexed at page 57 of the writ petition. Push up next para. By the said notification, comma, you have challenged 55 and 56.
Sorry for the interjection. Millard, the last document which we could obtain, that 10th February 2025, if Millard looks at it, it is in the nature of a proposal. Deputy Secretary writing to the Principal Secretary.
What are you challenging?
But in consequence of that, the gazette notification Mr. Chaudhary has produced, Millard can take that on record. So we have challenged this also, 10th February 2021, that this cannot go ahead.
A gadget notification na kore, a communication
Yes.
from the Deputy Secretary, comma, Government of West Bengal to the Principal Secretary, comma, Judicial Department, comma, Government of West Bengal, whereby it was suggested that a gazette notification be issued conferring jurisdiction in respect of 2 STF police stations vis-a-vis the respective jurisdictions of criminal courts for trial of specific offences as per the proposal therein below. Full stop. Learned AAG, comma, appearing for the state, comma, has produced before this court a notification dated May 14, 2025, pursuant to the said communication. Full stop. Next para, in effect, comma, the challenge preferred in the writ petition merges into a challenge to the gazette notification dated May 16, 2025, dated to a notification dated May 14, 2025, comma, published in the Kolkata Gazette on May 16, 2025. For sub next para, learned counsel for the petitioner contends that the conferment of jurisdiction in respect of 2 STF police stations on criminal courts, on particular criminal courts in the notification is grossly violative of the entire scheme of the Bharatiya Nagarik Suraksha Sanhita, comma, 2023, bracket BNSS. Push up, learned counsel places reliance on section 175 within bracket 1 of the BNSS, which provides that any officer in charge of a police station may, comma, without the order of a magistrate, comma, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter Roman 14, Full stop. Next para. Learned counsel further places reliance on chapter 14 of the BNSS, which is captioned within double inverted jurisdiction of the criminal courts in inquiries and trials, double inverted close, full stop. The first section under the said provision, comma, section 197, comma, deals with the ordinary place of inquiry and trial and provides that every offense shall ordinarily be inquired into or tried by a court within whose local jurisdiction it was committed. Full stop. Next para. It is contended that the exceptions carved out under chapter 14 pertain to the specific circumstances as indicated therein and do not operate on a general footing. Full stop. Next para. It is sought to be argued that the exception to territoriality as embodied in certain sections of the BNSS, comma, such as section 508 and 511 all pertain to post facto irregularities. Full stop. In section 508, comma, the provision refers to findings, comma, sentences or orders by any criminal court which would not be set aside due to certain irregularities as provided therein, comma, as is section 511. Full stop. Next para. However, comma, by the impugn notification, comma, which is a culmination of two prior notifications, comma, the entire jurisdiction in respect of investigation as well as registration of FIRs has been conferred on two particular courts situated in two particular areas respectively for the entire districts of North Bengal and South Bengal. Full stop. Next para. Learned counsel refers to a prior gazette notification, dated January 30, 2025, comma, which was published in the Gazette on February 28, 2025, whereby, comma, purportedly in the exercise of power conferred by clause small u within bracket of subsection 2 within bracket of section 2 of the BNSS, comma, it was declared that the places mentioned in the schedule therein below as special task force police stations, special task force police stations, and also specify the local areas of the said police stations for the purposes of investigation of the offences mentioned in the said schedule. Full stop. In the third column of the said schedule, comma, the offences to be investigated have been enumerated, comma, which all pertain primarily to special statutes, comma, such as the NDPS Act, comma, the Arms Act, comma, the UAPA Act, comma, PMLA, etc. Full stop. Next para. On the left-hand column, comma, the name of the police station, two names of police stations have been provided. Full stop. The STF headquarters police station situated at Salt Lake has been granted jurisdiction within bracket local area of the police station of all the districts of South Bengal, comma, taking from Murshidabad to Purbo Medinipur, comma, excluding territorial jurisdiction of Kolkata police. Full stop. On the other hand, comma, the second police station mentioned there is the special task force, comma, Siliguri police station situated at Ambika Nagar, comma, which has been conferred the jurisdiction of all the northern districts of Bengal, of West Bengal. Full stop. Next para. Thus, comma, the investigation in respect of the said districts have been confined to two focal point police stations. Full stop. Next para. By the notification dated January 31, 2025, comma, to enable the STF West Bengal to register FIRs in respect of the specific offences assigned to it and for enhancing the effectiveness of the STF, 2 dedicated police stations under the STF were set up. Full stop. Sanction was accorded by virtue of the notification dated January 31, 2025 for the creation of 40 regular posts in different categories of the said police stations. Full stop. Next para. The above exercise culminated in the communication dated February 10, 2025 and ultimately in the notification dated May 14, 2025, published in the Gazette on May 16, 2025. Full stop. As per the Gazette notification, referring to the earlier notification dated January 31, 2025, whereby two STF police stations were created, the notification further refers to the judicial department, refers to a purported reference being made to the judicial department under the state government for bringing the newly created two STF police stations under the respective jurisdictions of criminal courts for trial of the offences mentioned in the said notification. Full stop. In the third paragraph, conspicuously, it has been stated that the judicial department of the state government vide its letter number 84-JD/L/16M-43/21 dated April 8, 2025, had informed that the Honorable High Court, Calcutta, has been pleased to assign the jurisdiction of criminal courts in respect of the newly created STF HQ police station and STF Siliguri police station for trial of the offences. Full stop. In terms of the said purported assignment of jurisdiction by the High Court at Calcutta as communicated to the Judicial Department, citing those as the justification, the jurisdiction of the police stations have been brought under the jurisdiction of the Additional Chief Judicial Magistrate Bidhannagar and Additional District and Sessions Judge at Barasat, insofar as the southern districts of West Bengal are concerned, and the Additional Chief Judicial Magistrate Siliguri and Additional District and Sessions Judge, Second Court Siliguri, Darjeeling, have been conferred the jurisdiction in respect of all the northern districts of West Bengal, which come under their respective STF police stations. Full stop. Next para. Learned counsel for the petitioners contends that constitution and designation of courts falls within the specific domain of the legislature and cannot be conferred by executive action. Full stop. Next para. Learned counsel refers to the legislative power of the state under the state list, which falls within schedules, the 7th schedule of the Constitution, which deals with jurisdiction and powers of all courts except the Supreme Court, in respect of public order and police. Full stop. Next para. Thus, it is argued that the jurisdiction as conferred could only be done by the legislature and not by the executive. Full stop. Next para. Learned counsel submits that in cases of previous instances where the Supreme Court had passed certain directions regarding creation of courts, the said position was clarified by the Supreme Court itself in Ashwini Kumar Upadhyay versus Union of India (writ petition civil number 699/2016), where it was held that the order of the Supreme Court makes it abundantly clear that instead of designating one sessions court and one magisterial court in each district, the high courts were requested to assign and allocate criminal cases involving former and sitting legislatures to as many sessions courts and magisterial courts as each high court would consider appropriate, fit and expedient. However, the directions were clarified not to supplant SUPPLANT, the jurisdictional provisions contained either in the Code of Criminal Procedure 1973 or in any other special enactments governing the trial of offences governed by those enactments. Full stop. Next para, learned AAG, comma, while arguing on behalf of the state and opposing the writ petition, comma, seeks to hit at the very root of the writ petition as a public interest litigation. Full stop. Learned Counsel places reliance on such and such reported at 2010 3 SCC 402, where it was categorically observed by the Supreme Court, comma, inter alia, that instead of every individual judge devising his own procedure for dealing with PIL, comma, it is appropriate for each High Court to properly formulate rules for encouraging genuine PIL and discouraging PIL filed with oblique motives. Full stop. The Supreme Court highlighted further that before entertaining PIL, comma, the court should ensure that it is aimed at redressal of genuine public harm or public injury, and the court should also ensure that there is no personal gain, comma, private motive or oblique motive behind filing public interest litigation. Push the next para. In such context, comma, learned counsel places extracts from the pleadings in the writ petition itself, where it has been pleaded that the conferment of jurisdiction challenged in the writ petition shall directly affect the livelihood of the advocates and their practice. Full stop. Next para. Next para, learned AAG further contends that the expression double inverted local is not confined to section 2 within bracket 2 within bracket small u or section 197 or section 175 of the BNSS, but has to be traced to clause small n of section 2 within bracket 2. Full stop. The said clause provides that local jurisdiction double inverted moddhe, comma, in relation to a court or magistrate, comma, means the local area within which the court or magistrate may exercise all or any of its or his powers under the Sanhita S capital, and such local area may comprise the italics say the whole of the state, comma, or any part of the state, comma, as the state government may, comma, by notification, comma, specify. Full stop. Thus, comma, in the present case, comma, the state government was well within its powers to confer local jurisdiction to particular courts of magistrate in respect of the statutes in question. Full stop. Next para, learned AAG next places reliance on section 7 of the BNSS, which provides for territorial divisions. Full stop. Subsection 1 thereof stipulates that every state shall be a sessions division or shall consist of sessions divisions, semicolon, and every sessions divisions shall, comma, for the purpose of the Sanhita, comma, be a district or consist of districts. Full stop. Subsection 2 provides that the state government may, comma, after consultation with the High Court, comma, alter the limits or the numbers of such divisions and districts. Full stop. Under subsection 3, comma, the state government may, comma, after consultation with the High Court, comma, divide any district into subdivisions and may alter the limits or the number of such divisions. Full stop. Next para. It is contended that the reference to the High Court in the notification dated May 14, 2025, which is impugned herein, clearly comes within the ambit of section 7, which provides for consultation with the High Court. Full stop. Next para, learned AAG further submits that, comma, if given some time, comma, he would be able to produce the communication from the High Court in that regard. Full stop. Next para, learned AAG contends that there is no bar in any law whatsoever, comma, in the formation of a special task force for the handling of particular offenses under particular statutes. And as such, comma, since after the initial formation of the STF by the original notification of 2019, comma, certain difficulties were faced by the STF. Full stop. As per the notification dated September 9, 2019, comma, exercising the powers conferred under Section 2 of the Police Act 1861, read with Section 2 of the Bengal Police Act, 1869, the special task force had been created for dealing with various natures of offences like terrorism, circulation of fake Indian currency note, etc., which directly hit at the sovereignty of the nation and are of extreme importance. Next para. What was happening was, according to learned AG, was that the complaints were lodged and FIRs registered in the respective concerned local police stations, and thereafter the matter, when the investigation was handed over to the STF, by that time, many of the documents went missing and the relevant evidence or the witnesses and stroke or the accused persons had already gone outside the reach of the STF, which directly affected the quality of the investigation. To obviate such difficulties, the present notifications have been issued. Thus, it is argued that the notifications were fully within the executive competence, and the challenge thrown is frivolous. Next para. At the present stage, as clarified to learned counsel, we are only to consider whether a prima facie case for grant of interim orders has been made out. Next para. On a bare perusal of Section 2 small n of the BNSS, it is found that the same deals with the local jurisdiction of the courts or magistrates and not of the police stations. Next para. The said jurisdiction, local jurisdiction, close kore, cannot percolate down to the territorial jurisdiction of the police station as such. Undoubtedly, the state government may by notification, fix the local jurisdiction of courts or magistrates in respect of either the whole of the state or any particular area or any part of the state as the state government deems fit. Next para. However, the case at hand does not contemplate a situation where the state created the jurisdiction of the courts and thereafter proceeded to designate the police stations and so on and so forth. It is just the other way round, where a task force was created first and thereafter the task force were designated particular police stations, and thereafter the said police stations were tied to the existing magistrates and courts. Next para. If we look at the intent of Section 175 (1) of the BNSS, the said provision clearly stipulates that any officer in charge of a police station may, without the order of a magistrate, investigate and any cognizable case which a court having jurisdiction over the local area within the limits of such station, close, would have power to inquire into or try under the provisions of Chapter XIV 14. It is crucial to distinguish between the term local jurisdiction in Section 2 small n, which refers to the local jurisdiction of the court of magistrate, with the expression local area within the limits of such station, close, which the latter only referring to the territorial jurisdiction of the local police station. Thus, the expression local in Section 2 small n is completely different from the expression local as used in Section 175. whereas the former refers to the jurisdiction of the concerned court or magistrate, comma, which can be created by the state, comma, section 175 is governed by the local area within the limits of the police station, which has to be tied up, TIED, tied up with the territoriality of the police station. Full stop. Next para, the jurisdiction of the magistrate is governed by the local area of the police station in that context as well. Full stop. Next para. If you look at the scheme of the BNSS in general, comma, there are other provisions which also indicate towards the same proposition. Full stop. Section 223, for example, comma, contemplates a magistrate having jurisdiction while taking cognizance of an offence on complaint, comma, which magistrate is conferred the power to examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses, and also by the same magistrate. Full stop. Next para. Section 223 relates back to the power of taking cognizance under section 210, which provides that subject to the provisions of the chapter, that is chapter 15, comma, any magistrate of the first class, etc. may take cognizance of any offence upon receiving complaint of facts, including any complaint filed by a person authorized under any special law, etc. Full stop. Next para. Section 511 of the BNSS provides that no finding, sentence, or order passed by a court of competence jurisdiction shall be reversed or altered by the court of appeal, comma, etc., merely on account of any error, omission, or irregularity in the complaint, comma, summons, comma, etc., or irregularity in any sanction of the prosecution, etc. Full stop. Next para. Thus, comma, we find that the entire scheme of the BNSS is tied up with the jurisdiction of the magistrate, comma, which has to be fixed independently and percolate down to the police stations, and the entire act from lodging a complaint, comma, registration of an FIR and taking cognizance of the same. Full stop. The journey of the law is not the other way round, that a particular police station is vested with jurisdiction, and thereafter such jurisdiction, that a special police force is created and conferred jurisdiction to take up investigation in certain offences, and thereafter special police stations are created for the jurisdiction, and subsequently, comma, the jurisdiction of the police stations govern the jurisdiction of the magistrate. Full stop. Rather, comma, it is the other way round. Full stop. Hence, comma, we do not find any applicability of section 2 within bracket small n of the BNSS in the present case. Full stop. Even in the notifications in question, comma, the said provision has not been mentioned, comma, although the initial notification, although the notification date January 30, 2025, by which the investigation of offences of particular types was entrusted to the STF by citing section 2 within bracket small u of the BNSS. Full stop. Next para. 22 u. All right.
It should be 2U, and 2N, not 2.
Of course, comma, we gloss. Of course, comma, we gloss over the mistake in the notification insofar as the reference to section 2 within bracket 2 should have been read as section 2 within bracket 1. Full stop. Be that as it may, comma, subsection small u within bracket of section 2 within bracket 1 refers to a police station to mean any post or place declared generally or specially by the state government to be a police station, and includes the italics say any local area specified by the state government in this behalf. Full stop. Next para. It is to be noted that the specification by a state government of the local area of a police station is completely distinct and different from the fixation of of the local jurisdiction of a magistrate under section 2 within bracket 1 within bracket small n of the BNSS. Full stop. The two cannot be confused in the present case. Full stop. In the present case, comma, what has been done is that a power has been purported to be exercised under section 2 within bracket 1 within bracket small u by stipulating the jurisdiction of the STF police stations to particular local areas which pertain to the entire pertain to TWO2 entire halves of the state of West Bengal. Full stop. It is conspicuous to mention here that unlike clause small n, where local area has been stipulated to comprise either the whole of the state or any part of the state, comma, in clause small u, comma, the expression used is local area, double inverted মধ্যে, without any such qualification that the local area may comprise of the whole of the state or any part of the state. Full stop. Thus, comma, in contradiction with small n within bracket, comma, small u does not refer to local area as the whole of the state or any part of the state, but clearly refers to the actual location of the police station. Full stop. Keeping this distinction in mind, comma, if we view the scheme of the provisions of the BNSS, comma, including section 175, comma, the jurisdiction of the magistrate has to be determined by the local limits of the police station. Full stop. Next para, section 2 within bracket 1 within bracket small u, comma, read in conjunction with section 175 within bracket 1 leaves no manner of doubt, comma, at least at a prima facie level, comma, that local area of a police station means actually the territorially local and geographical location of the area of the police station and not any area of the state which can be picked and chosen by the state at their whims. Full stop. Next para, in fact, comma, even on a basic rational basis, comma, it is well settled that access to justice has been included within the concept of equality as contemplated in Article 14 of the Constitution of India, as well as a right to life under section Article 21 of the Constitution. Full stop. Access to justice is not only a fancy right given to the citizens of India, but is what distinguishes an autocracy from a democracy, comma, viewing all people equally in the eye of law and before the law. Full stop. The very concept of access to justice, comma, which is implicit in a rule of law, comma, would be utterly frustrated if a person, comma, for example, in Murshidabad or Jhargram has to go to the Bidhannagar or Salt Lake police station and lodge even the initial complaint, comma, or a person from Kuch Bihar has to come to Shiliguri to lodge a complaint. Full stop. Registration of an FIR and registration of an FIR. Registration of an FIR is the logical culmination of the lodging of a complaint. Full stop. Thus, comma, an FIR is integrally tied with the complaint. Full stop. If the notifications are to be given force, comma, then a person living in a remote area would in most cases, comma, never report any offense, that too under the high statutes regarding which investigation has been conferred to the STF. Full stop. Next para. Thus, comma, moreover, comma, as discussed above, comma, the upward percolation of jurisdiction as contemplated in the notification in question, comma, is not sanctioned by the general scheme of the BNSS. Full stop. As per the BNSS, comma, it is the local police station which determines the area of the magistrate at the first instance, and thereafter, comma, the upward progression of the trial commences. Full stop, the entire scheme of the BNSS has been sought to be frustrated by prima facie by the notification dated May 14, 2025, comma, published in the official gazette on May 16, 2025, which is challenged before us. Full stop, next para. We also would like to mention one alarming aspect of the matter. Full stop. Learned AAG, comma, as per instruction of the double inverted with the appropriate authority, double inverted clause, has submitted before us that it was this court, that is the High Court, Calcutta High Court, that was pleased to assign jurisdiction of criminal courts in respect of the newly created STF HQ police station and STF Siliguri police station for trial of the offences. Full stop. Next para. Although the BNSS contemplates a situation where the state government, comma, in consultation with the High Court, comma, can create certain jurisdictions, comma, we are at a loss to understand how this court can have the power in any law, comma, to create jurisdiction of criminal courts at the first instance. Full stop. Next para. In any event, comma, since no such order has been produced as yet before us, comma, we desist from commenting further on the same. Full stop. Next para. Be that as it may, comma, in view of the above discussions, comma, the entire constitutional scheme and the scheme of the BNSS, comma, according to us, is prima facie frustrated by the impugned notification. Full stop. Accordingly, comma, the operation of the impugned notification dated May 14, 2025, vide number 1352-PB stroke 14 capital M hyphen 162 stroke 19 within bracket P capital T small dot hyphen II bracket closed, comma, published in the official gazette of May 16, 2025, shall remain stayed till September 15, 2025 or until further order, comma, whichever is earlier. For some next para, it is made clear that FIRs which have already been registered with the designated police stations under the impugned notification and or ongoing investigations under the said provision at the present juncture or any further steps if might have been taken pursuant to the same till date, comma, shall not be affected for the present, comma, subject to the outcome of the writ petition, comma, by the order of stay as given above. Full stop. Needless to say, comma, the above ad hoc stay order is on a temporary basis and will be subject to the outcome of the writ petition itself.
STF exclusive jurisdiction.
Page
Acha,
55 also requires to be state probably. Constitution of the police station. You gotta
yes.
dealt with that this is not.
যেখানে বললাম যে state operation of such and such as well as operation of the notification dated January 30, 2025, vide number 289-PB stroke 14 capital M hyphen 162 stroke 19 bracketed PT hyphen II bracket closed, comma, published on in the Gazette on February 28, 2025. ওটাও অপারেশন অফ এইটা অ্যান্ড ওটা শ্যাল রিমেইন স্টেট। আচ্ছা, একটা স্টার্ট দিয়ে লিখে দাও, পরে ঢুকিয়ে দেবো অর্ডারে। Learned AAG also submits that exclusive jurisdiction has not been conferred on the STF police stations or the courts in question by virtue of any of the impugned notifications. Which of next para, however, comma, we are of the opinion that the said argument would further vitiate the creation, the conferment of jurisdiction on the particular STF police stations and the concerned courts, comma, since then it will be open to complainants stroke the state stroke the STF to pick and choose between complaints made under the special statutes which are envisaged under the notification dated January 30, 2025, and there will be a gross inequality in as much as some of such complaints, comma, FIRs will be registered by the local police stations and trial will go on in the jurisdictional courts otherwise, whereas a parallel exercise will be undertaken by the STF police stations by registering FIR and going forward with the investigation as well as the trial before the specially designated courts, comma, which creates two parallel hierarchies for the self-same category of offences, comma, which is also, in our opinion, prima facie violative of Article 14 of the Constitution.
Great.
For a limited period of stay seeking for preferring itself.
আচ্ছা লার্নেড এ অবভিয়াসলি লার্নেড এ আচ্ছা এটা হচ্ছে লাস্ট ঢুকবে ওটা স্টার্টটা ঢুকে যাবে তুমি বোল্ডে করে দেবে আলাদা ওটা ঢুকিয়ে দেবো মাঝে লার্নেড এএজি কমা আফটার পাসিং অফ দি অ্যাবভ অর্ডার কমা সিক্স a limited stay of operation of the above order for the purpose of preferring a special leave petition push up next para. However, comma, the very purpose of the stay order would be frustrated if a double negative is ensued by staying the operation of a stay order, comma, which would open up for the impugned notifications to be acted upon immediately. Push up. In such view of the matter, comma, we refuse to pass any order of stay of the above stay order passed by us.
I can note the circuit bench of Jalpaiguri extended the power of the southern Bengal by a notification.
Have you got we want a copy of the order all the same, Mr. Chaudhary?
The affidavits can be directed.
Oh,
Let
yes,
them- let
yes,
them-
definitely, definitely.
And will kindly mention that communication of the High Court has to be preemptively or mandatorily enforced in the affidavit.
That will embarrass us, so I go.
What do you?
But I am interested in looking at such communication. Mr. Chaudhary, because at a different level, we can take it up with whoever we have
Yes,
to.
exactly. That we want to know also what is.
And several things are happening in our court also, so. Anyway, the respondents shall file their affidavit. If you want to file affidavit, we can give you a short time. How, depends on Ms. Sarkar. She'll have to prepare it, or Mr. Pal, I don't know. Or somebody behind you. Both of you. So take 1 week. 1 week, yes. The affidavit in opposition, if any, act a line, affidavit in opposition, if any, to the writ petition shall be filed within a week from date. Reply, if any, shall be filed within 3 days within a week thereafter. Full stop.
Equally.
Yes, within a week thereafter, full stop. Liberty to the parties to mention the writ petition for inclusion in the list for hearing before the appropriate bench in the next circuit after the above timeline for filing affidavits is over. Said that. Said division. Appropriate division bench. We have said division. Oh, দাঁড়াও একটা ম্যাটার নিয়ে নি হ্যাঁ yes yes we'll take up the other division bench matter then we'll rise for 10 minutes and continue with the
I have a correction also. Small correction.
in the next matter Mr. Vishwas.
No, it is Mr. Santonu's matter. But yesterday, Manoj granted me a bail. So I needed one word correction. O and A, my lord. The name has changed. Sujon, O has been typed.
Of the accused.
Accused.
Haribab.
It has to be A. I will mention it after this matter is over.
We don't have the time. Don't have the time, but
Yesterday, Manoj passed.
we have, it is uploaded order.
Yes.
So we have to formally put it on the list and how?
Huh?
We'll have to formally put it on the list and do it. Don't have the time for that.
This man will be remaining in the jail.
Yes, we can't afford that. আচ্ছা একটা স্পেশাল লিস্ট বার করিয়ে কখন দেবে ছাড়তে হবে স্টাফ
Small correction, not just a light.
পিএম করে দাও সাপ্লিমেন্টারি লিস্ট করে ওটা প্লিজ গিভ আস ইট
Can this matter be also put as a special list, my lord?
yes you are saying something some correction
Lord, yesterday in the affirmative matter guardianship case, the lordship was pleased to pass an order and giving delegational right to the
what is the error
10,000 is too much for him here. My lord,
sorry
he is not in the condition to pay.
no that you have to argue before a different bench
20,000.
এটা ঢুকে যাবে ডাকো পরটা রাখো
8 and 9.
এই লিস্টটা বোধহয় চলে গেছে দেখুন
8 and 9.
না এখানে আছে yes
My lord, Lordship, and for that effect, I'm praying for not today, Your Lordship.
But the judgment was passed on 9th of July 2025. Death row convict, my lord. The 389(1) has been filed, my lord. So maintainability is for.
so very well we'll keep it you are for the petitioner
No,
For that
I am for
effect,
the
Your
petitioner, my
Lordship. Playing for not to.
You are for whom?
De facto, your lordship.
De facto has an active role in proxy matters.
Definitely. Single. Pass over করো না করলে এগুলো সব আর্জেন্ট সেম 2 আর 1 একই
Yesterday, I'm appearing on behalf of the respondent in this matter 1 and 2, your lordship. The difficulty is that.
Civil division opposite party, Ms. Acharya. Yes.
But your lordship, they have prayed for time yesterday as well, your lordship.
So why did you put it today? 1 and 2? Yes. You had prayed first time, Ms. Acharya.
She was praying on
Half of the.
No, they said they want to do it today, yes.
Lordship, matter is very simple one.
You have got a copy? No caveat.
First time.
Oh, yes. What is the matter?
Lordship, one appeal has been prepared by the defendants in the trial court
Right.
against the refusal of the reference of arbitration.
Section 8.
5 and 8. That has been rejected. Thereafter, one appeal has been prepared before the concern of the court with the stay application. that is on 15/1/2024. Till that day, this day, that application has not been heard and considered. And taking that advantage that the lower court record is.
You want a disposal of that application early? You want an early disposal of that application?
This one direction may be given to.
227 jurisdiction, otherwise cannot be exercised by us. I mean, under the act, we cannot exercise jurisdiction to look into the merits of that, but we can pass a direction that it will be.
Lords,
When was it filed? Stay
on
application.
15/1/2024. And my difficulty is that the lower court record is there.
So this is a stay application filed in connection.
And I am confined with that stay application.
Ms. Acharya will record your presence. Have you got vakalatnama? So we'll permit you to file during the course of the day and we'll record your presence and say that this is the innocuous and give a copy to him, her, please.
This is obvious.
Takes it fixed on 2nd of September 2025, your lord.
We'll direct it to be positively heard out on that date. And if you, have you filed any objection to that? We'll put it in our order that if not filed, you will file it within that date with a copy to them. The innocuous prayer in the present application under Article 220, why two? Two separate suits, two separate, here. 1 and 2. Acha. The present, the two applications are taken up together for hearing since they arise in connection with connected suits and between the same parties. Full stop, next para. The innocuous prayer made in the applications under Article 227 of the Constitution of India is that despite a challenge having been preferred under Section 37 of the Arbitration and Conciliation Act 1996 against an order whereby an application under Section 8 of the said Act was rejected.
By the trial court.
Yes, was rejected by the trial court, and an application for stay having been filed in connection with the said appeals, an application corner, and applications for stay having been filed in connection with the said appeals, comma, the said stay applications are not being disposed of, comma, all despite those having been filed long back on
Lordship, 15/1/2024.
both,
Same.
on January 15, 2024. First of next para, in view of the urgency involved implicitly in such an application, comma, CO number 148 of 2025 and CO number 149 of 2025 are disposed of. Onno file ta kothay? Eta, acha, thik ache. Are disposed of respectively by directing the
Additional district judge fast track court. Not it is pending court.
the learned additional district judge fast track court at Shiliguri to dispose of the interlocutory stay applications filed in connection with miscellaneous appeal number 03 of 2024 in connection with title suit number 91 of 2023 and miscellaneous appeal number 04 of 2024 in connection with title suit number 90 of 2023 as expeditiously as possible, comma, positively within September 2, 2025, comma, which, comma, we are apprised, comma, is the next date from for hearing the said applications. First of next para, written objections to the said stay applications, comma, if not already filed, comma, shall be filed in the meantime, and the copies thereof shall be served on the learned advocate for the petitioner appearing before the appellate court. First up, since Ms. Acharya submits before us that she has instruction to appear for the opposite parties, comma, in view of the innocuous nature of the order, comma, prior service of copy of the application is not directed and the order is passed in her presence. First up, however, comma, copies of the present applications under Article 227 of the Constitution shall be handed over to Ms. Acharya by the learned advocate on record for the petitioner during the course of the day. The parties shall act on the server copy of the parties as well as the appellate court shall act on the server copy of this order. Thank you.
Lower court also, because the lower court is continuously proceeding. That is given
As well as the trial court,
Lordship,
appellate court as
Lordship.
well as the trial.
Deep, yeah.
Thank you. Ensure that copies are, act line add karo, leave is granted to the learned advocate appearing for the opposite parties to file her vakalatnama during the course of the day in both the matters. Next. Thank you. Yes. 3 yes, It is a different matter, yes.
Lordship, I am taking liberty to file some documents which have been. not
Supplementary
balanced with
affidavit?
my application.
Appearing for the first time?
First,
Right. What is the matter?
this is the suit for declaration, injunction and consequential filed before the civil judge Mirik. Other side appeared before the court on the very first day injunction has not been granted as because the state was the party. Defendants appeared before the court and filed one application under order 7 rule 11 of civil. That has been allowed. Against the impugned order, this revisionist has prepared one appeal before the additional district judge Curtian, having the jurisdiction.
Right?
In that application, that appeal, one injunction application has been filed with the prayer for securing the possession.
Who has filed that? You.
Yes, Lordship. And that injunction heard and that has been refused. Prayer of the injunction has been refused.
Possession, securing possession, how can you get it at this stage?
This is the suit for the adverse possession of. Since 100 years, my predecessors and.
No, securing possession means you want it.
To change nature and character of the suit property till disposal of that. Only that prayer. Maybe in the way of status quo.
Why was it refused?
Refused. I didn't get any concrete findings,
What is the certificate copy?
save and accept.
Let us see the certificate copy. Where is the certificate copy? No certificate.
Yes, certificate copy. In this way, they.
This is not a certificate copy. This is an ordinary copy.
When the revisional application was filed, leave was granted by the honorable court, and after in the due course of time, I have filed the original certified copy.
Certificate copy, you don't find it.
It is filed in the department, and I have given the number is 909.
Acha, we will direct the department to tag. And let us see the reason for, yes, let us. Not maintainable, it seems. No, it has relied on a Supreme Court judgment which says in a commercial court, but
No judgment, Lordship. That is my problem. That is the only findings.
no, this Mumbai section welfare supra.
No, I searched that such type of no judgment has been passed and no reported judgment is there. Only the one findings in respect of one commercial dispute. And I made objection
Why was this rejection of plaint made in your case? What was the ground for rejection of plaint?
that I have no cause of action. As because the property is the government land, as per the version of the state.
Learned counsel for the petitioner argues that the petition,
Should I refer only one document?
yes,
In my annexure,
supplementary or,
supplementary, that's just I handed over.
yes, what is this?
Lordship, please come into the page number 47 P2, sorry, 3, page number 3, P2.
47.
No, page number 3, annexure P2. Annexure P2, only 3, page number 3.
Yes,
This is the certificate issued by the revenue officer Darjeeling
regarding your
in the
possession,
year of 1984.
regarding your possession.
Yes. And continuously I have been residing there and I have been possessing the property.
So what is the injunction sought here?
Injunction sought not to disturb my peaceful possession. One eviction notice has been served by the BLN arrow and that has not been disposed of at all.
Learned counsel for the petitioner contends that the learned counsel for the petitioners contends that the petitioners filed a suit for declaration of title, permanent injunction and consequential reliefs. Full stop. The plaint of the said suit was rejected by the learned trial judge on the premise that no cause of action has been disclosed. Full stop. Next para. Against such rejection of the plaint, which is a deemed decree, an appeal has been preferred, in connection with which an application for injunction was filed restraining the opposite parties from disturbing the peaceful position of the petitioners in respect of the suit property. Push-up, the learned appellate court has refused such injunction, prompting the petitioners to approach this court. Push-up, next para. The learned appellate court, as it appears from the impugned order, placed reliance simply on a finding of the Honorable Supreme Court in the matter of LEE, Mumbai Section Welfare versus Global Institute for Engineers, Civil Appeal number 7235 of 2025, for rejecting the plaint. First up, next para. The observation from the said judgment of the Supreme Court, as quoted in the impugned order, indicates that the Honorable Supreme Court observed that the High Court ought not to have granted an order of temporary injunction since the plaint itself had been rejected by the Commercial Court, and the correctness or otherwise of the said rejection is a matter at large before the High Court. For some next para, learned counsel for the petitioner argues that the premise of the said judgment was merely that the non-commercial dispute had apparently been filed before the Commercial Court, which is a palpable bar of law, as opposed to the present case where the allegation against the petitioner is that no cause of action was disclosed, which has to be gone into on merits. For sub next para, upon hearing such submissions, this court is of the opinion that learned counsel for the petitioners is justified in arguing that the question as to whether any cause of action was disclosed in the plaint has to be gone through not at the threshold but upon a thorough perusal of the plaint and consideration of the appeal on merits. First up, in the event the petitioners are dispossessed in the meantime, the entire appeal, and consequentially, if the petitioners succeed in the suit, succeed in the appeal, the suit, shall become infructuous. First up, moreover, as per the annexure annexed to the supplemented affidavit filed today with the leave of court, it transpires prima facie that the petitioners are in possession of the property. Full stop, next para. Thus, the opposite parties shall remain restrained by an order of injunction from disturbing the peaceful position of the petitioners in respect of the suit property without due process of law till September 15, 2025 or until further order, whichever is earlier. Full stop. The petitioners shall serve copies of CO number 150 of 2025 along with the supplemented affidavit filed today on the opposite parties, indicating that the matter shall be listed before the next circuit, subject to being mentioned before the appropriate bench in the next circuit. Push up next para. The petitioner shall file an affidavit of service on the returnable date.
Deeply honest.
Lordship, I am appearing for the petitioner in this matter.
Yes, Mr. Dhar.
I'm appearing for the opposite party bank.
Lordship, the
right.
matter is relates to payment of surfacey demand, and from the very beginning of my submission, I made a submission before your Lordship that petitioner is agreeable to pay the entire amount of 7,42,629 and 83 paisa only by 3 installments. First to be paid by Monday, first to be, and the rest amount to be paid by within 2 months, Lordship.
What have you challenged, Mr. Dhar?
Lordship, he is
I have
challenging a
challenged-
notice.
Mr. Choto Mr. Dhar, please let Boro Mr. Dhar speak.
Lordship.
Yes.
Lordship, kindly have a look on the notice being P8 demand notice. Now, before going to that P8, first Lordship, kindly look page 65, 66.
Yes. Surfacey
And
action
before
has been
that, I will
initiated,
draw up
Mr.
your
Dhar.
Lordship's attention.
Mr. Dhar, this is not a matter where 227 interference can be done. This is clearly barred by section 34 of the Surfaei Act. This is a
No.
13-4 dispute. So no scope of, if the bank is agreeable, Mr. Choto Dhar, if you are agreeable, you take instruction.
My first point is I am challenging the maintainability of this civil
The
division.
first point we have also were accepting, but If you are agreeable, because your main purpose is to recover the amount. If they are agreeable, whether you are take instruction on that.
My instruction is that
Lordship, there are
his outstanding as of today is on principal amount is 9,26,945 plus interest and other charges, Lordship. Can that be adjudicated in the civil divisional application, Lordship?
No,
I'm challenging the maintainability of this application.
Lordship,
he's right.
Lordship, before that, kindly come to two order of this honorable court passed in a writ petition.
Where is that?
Lordship, the first order is annexure P3. That was the order dated 3rd of December 2024. What happened, Lordship? They have initiated section 14 proceedings. In the proceedings, I have paid the check of entire amount, and that was not considered. No order is passed. Again, I came before this honorable court, and my Lord Justice, and in the court, Lordship, by the said writ petition number 2373. It is passed that if the by Justice Biswajit Basu, that the petitioner shall shall pay before the district magistrate, and accordingly we again pay the check to them, but suppressing that they did not pass any order. Then I compelled to come before this honorable court, and after that the annexure P5, Lordship, that is order 9425, wherein they have told the court that they have passed an order, but no order is communicated, and this honorable court specifically directed to communicate the order of, if any, passed by the district magistrate within 2 weeks. That 2 weeks lapse. Now subsequently on 4th of July, and no order is communicated up till now. Now subsequently on 4th of July, this demand notice is issued. So Lordship, when I am agreeable to pay whatever the amount, let them decide.
No, from the writ petition, it's not clear. The constantly, it's not clear what you are challenging, Mr. Dhar. What is the prayer portion? What have we challenged actually?
Prayer portion is challenging the notice dated 4th, where we have taken the physical possession of the property. This physical possession of the property has been taken pursuant to order passed under section 14 by the district magistrate, which we had.
But that order till not communicated as in spite of
Mr. Dhar, Mr. Dhar, there is no scope of challenging this notice. This is only a communication of the order passed by of the possession being taken. So where is the scope of challenging this in a writ petition?
Lordship,
even if you set this aside, even if
the dispute is, Lordship, only
Mr. Dhar, this is not an adjudication. This is a communication of position being taken. So what is the scope of an adjudication by setting aside this?
Because he is an authorized officer, Lordship. So we are agreeable to pay the entire amount. What interest of the bank to retain this property? If the amount is 10 lakhs, Lordship, we will pay that only by 3 installments within 3 months.
Position has been taken. There is no scope of interference. You can only.
Position has been taken, Lordship. 1/4 position has been taken pursuant to the order passed by under section 14, Lordship.
And that order, in spite of court's order, Lordship, not communicated to us to resolve our remedies. But I am not disputing all these things. Lordship, I am not on dispute. I am agreeable in terms of
no,
court's
Mr.
order.
Dhar, no, Mr. Dhar. There is no scope of it. Sorry.
Order which is under challenge.
No, there is no order under challenge.
I'll pay the entire dues.
No, Mr. The revision, the 227 is not maintainable at all. Entire dues, if you pay, they will consider.
Then let them to comply the court's order. That order can be passed, Lordship.
There was not a direction. Learned counsel for the petitioner contends that the petitioner, being a borrower under the Surfaei Act, had come up challenging an order passed under section 14 of the Surfaei Act by the concerned district magistrate before this court. There were 2 previous orders by 2 coordinate benches on earlier occasions, whereby the bank was directed to serve a copy of the communication, concerned communication on the petitioner, which has been violated by the bank according to the
Lordship, district magistrate also. He has also not
by the bank as well as by
the
bank as well as by the district magistrate. Next para. However, on a bare perusal of the present application under Article 227 of the Constitution, we find that the same merely challenges a possession notice annexed at page 65 of the application, which is merely a communication to the effect that the borrower, having failed to repay the amount, notice was given to the borrower and public in general that the undersigned, that is the authorized officer of the UCO Bank, has taken possession of the property described therein below in exercise of the powers conferred on him under subsection 4 of section 13 of the said Act, with Rule 8 of the Security Interest within bracket enforcement bracket close rules, 2002 on July 4, 2025. Full stop. Thus, the impugned notice does not comprise of any adjudication at all, but is merely an intimation that possession has already been taken. Full stop. In any event, if any dispute is to be raised in respect of the root cause of action of such possession being taken, it is always open before the petitioner to approach the concerned debts recovery tribunal. Full stop. Next para, although learned counsel for the petitioner expresses the intention of the petitioner to clear off the entire dues by 3 installments, since the writ petition is prima facie not, since the present application is prima facie not entertainable, there is no scope of granting such relief to the petitioner at all. Full stop. Next para, accordingly, CO number 155 of 2025 is dismissed as not maintainable without any knowledge to costs. Full stop. However, nothing in this order shall prevent the petitioner from approaching the opposite party bank directly to explore avenues of amicable settlement, if any. Full stop. If so approached, the bank shall take heed of the said approach.
Not possible. Then he will be using this order as a. He will be using this
The
order.
bank will be at liberty to consider such proposal of the petitioner in its discretion and in accordance with law.
Grateful, Lordship.
Lordship.
The state is represented.
Yes, definitely. Vociferously represented. You argued twice. So, agreed. Yes. Yes.
হচ্ছে না কেন স্টার্ট ভিডিও স্টার্ট হচ্ছে না
Yes.
তো
Yes, what is the matter?
I'm the opposite party, I led by Mr. Tapas Kumar Bhattacharya.
Yes, Mr. Datto.
The petitioner was the defendant in the suit. The case is that the plaintiff and the defendant were the partners. And during the course of the partnership, the defendant is the sleeping partner. He needs to sign some blank challenge for the business of the firm.
Mr. Datto, can you come back at 2? The rest of you, because we have a short meeting at 1:30. So, and 2 p.m. One matter, one letter correction we'll sit in division bench for half a minute and make that correction and go down, and immediately I'll come back for taking up the rest of the single matters.
But
2. We have already,
1:30?
Yes, because we have already issued a supplementary notice, which will be communicated to you, both of you. So we'll take that matter, division bench matter at 2, half a minute matter,
Yes,
immediately
yes,
after. Rest of the single bench matters will be taken up. So, thank you. Mr. Bhattacharya, please come back at 2, 2 past 2, say.
At 2?
Yes, you come
Yes.
at 2.
Yes.
My lord.
Mr. বিশ্বাস,
One
what?
correction, the name is Sujan.
All right.
It has been recorded as Sujan Jon.
In the order dated August 1, 2025, comma, the name of the petitioner was erroneously mentioned as Sujon Roy instead of Sujan Roy. Full stop. Next para. Let the order dated August 1, 2025 be deemed to stand corrected to the effect that double inverted Sujon O Roy should be read as double inverted Sujan Roy. Full stop. Such correction be effected in the order dated August 1, 2025 by the office as per direction of this court for the purpose of issuance of certified copies and communication.
My lord, one addition, my lord, I pray for, my lord, this plain copy direction, the server copy direction, the parties to act on the basis of.
The party shall act on the server copy of such order without insisting upon prior production of communication through court and stroke or certified copy.
Oh,
Parties and all concerned put the all concerned. Thank you.
oh,
এইটা না এটা একটা এক্সেপশন হবে, এটা ওই অফিসকে এই আমাদের অর্ডারটার উপরই কারেকশনটা আমার ডিরেকশন আছে, আমাদের অর্ডারটার উপরই কারেকশন হবে, তাহলে ফিউচারে এটা হতে থাকবে ভুল। ঠিক আছে, উইল রাইজ এন্ড সিট সিঙ্গলি ইমিডিয়েটলি। Divangar, call করছেন।
Number 5 will continue.
Yes, yes, Mr. Watt.
Yes, but I'm for the plaintiff of the part.
Oh, right. Yes, Mr. Watt.
Yeah.
Yes, what is the matter?
The present suit is between the plaintiff and defendant. The petitioner is the defendant here. The plaintiff and defendants are the two partners of a partnership firm. And during the, as the partnership process, as per convention, the plaintiff defendant is to depend on a sleeping partner. She is to put the signature on some challans for the purpose of the smooth functioning of the business. Now, when the dispute between the plaintiff and the defendant arose, that one of the challan has been used as manufactured as a acknowledgement of a loan, and on the basis of that acknowledgement of loan, the suit has been filed.
Loan between the two partners.
Between the two partners. Now,
The suit has been filed for money by the plaintiff.
by the plaintiff. Now, these defendant particularly challenge that handwriting written in the challan,
Of course.
and that. And
No, but you said that those were obtained under a different pretext.
on the different pretext, the signature was admitted. Signature is admitted. Signature is admitted on the
So
different pretext.
signature you cannot challenge because
No,
it's
signature
against.
is not challenged.
So what you?
But the handwritten documents of acknowledgement
Oh, acha.
that kindly come to the page number.
Let us see that a copy of that.
Page number 43.
This is that acknowledgement.
This is that. This is a challenge.
All right. Understood. So this entire handwriting you are trying to.
I'm disputing, and it is the version of the plaintiff that this handwriting is of the husband of the
You.
defendant.
Yes.
But when we prayed for the handwriting expert.
So you have to compare the handwriting of your husband with this.
With this.
So you sought for that.
Yes.
Refused.
That was refused.
Why?
Refused only on some assumptions.
Like?
And on different considerations.
Let us see.
The learned trial court came that the husband's signature, we haven't admitted, or that is not the case, that the husband is the signature. Here came with the firstly that husband is the signature. And thereafter, while going on deciding the case, if the learned trial court prejudge the evidentiary value of the. Sir, and while prejudging the said evidentiary value, learned trial court held that the challan were executed.
No, it is asserted by the defendant that her husband put his signature on blank check.
No, that is not the case.
That's not your. You filed a written statement.
Yes.
So it's not your
It
case.
is not the case of plaintiff, not the defendant.
Yes, all these things.
And thereafter,
Yes.
he proceeded to decide the case that the challan were executed. Now, that has been turned down by the Supreme Court. The execution is by
No,
signature.
where does it, in this impugn order itself?
No, in the impediment that the challan were executed, here, trial court while prejudging the evidentiary value, came to conclusion that besides that in that case, the person in whose favor the challan were executed, he came to that the execution of the challan done by the
Where is that finding?
in this second part, second page of the order.
Yes, second page.
Uh,
Sentence
is-
starts with?
It is asserted by the defendant.
Yes, that is the first
that,
sentence.
Thereafter, no person should be allowed to take such plea and evade the responsible is simply acting that he put his signature on the document lying blank. If that merely will follow the argument, commercial immorality would encourage. Besides, in the case, the person in whose favor the challan were executed remain physically, practically remedialess. A business document admittedly bearing the signature of the executant should be rendered useless at the whims of the executor. Now here, the learned trial court tried to state that it is executed, but that document has not been executed. And
yes.
it is also not a business document.
And just show me your prayer in the your handwriting expert application.
Page number
76.
77.
Yes, thank you, Mr. Yes, Mr. Bhattacharya, what defense?
My submission before Lordship,
Hmm.
evidence of the party that has been admittedly exhibited. That has been marked as exhibited. Then evidence of the PWD and DW has already completed.
The document
the
has been
matter-
marked as exhibit. The document.
Exhibited.
That
Document
does not
marked
mean
as-
necessarily that the contents have been admitted.
Contents have already is written, but the signature has been admitted. My
Yes.
submission before Lordship, my lord, when that was placed for argument, that he came with an application under Order 26 Route 10A for
Hmm.
sending the document to the expert. My
Hmm.
submission before is Section 73 of the Indian Evidence Act. Indian Evidence Act, my lord. Section
73 is-
73. Indian Evidence Act. But I'm reading. In order
Yes.
to ascertain whether a signature or writing or seal is that of the person by whom it purports to have been written or made, any signature, writing, or seal admitted or proved to the satisfaction of the court to have been written or made by that person may be compared with one which is to be proved, although that signature, writing, seal has not been produced or proved by any other purpose. Court may direct any person present in court to write any words or figure for the purpose of enabling the court to compare the words or signature so written with the words or figures alleged to have been written by such person. So my submission before Lordship, the court has ample power. What the court, but kindly see the impugn order. Kindly see the input. I'm reading on the impugn order.
Court does not do that. Court does not do that.
Yes, but court has ample power. Court has
Court
ample
has the
power.
power. It
But
has to be
then
read
you
with
also
section.
direct the court. The court has ample according to Section
No,
73.
no,
my
the court is
see.
not a, Mr. Bhattacharya, 73 has to be read with 45.
Read is 45.
Read with
Yes.
45. That
Yes,
is well
yes,
said.
I'm reading 45.
They've
I'm
asked
reading
for 45 and that's a relevant proof. And one of the parties wants to prove a relevant fact by way of handwriting expert. So
But
what's
it is
the harm?
true, Maharaj, this is a blank challan was handed over for the business purpose. Signature is admitted.
How can you have
But
an assumption? Yes. So
But
what?
signature is admitted.
Signature was on a blank paper and her husband's signature was impersonated. That is her case.
That is their case, Maharaj. Yes, but you're also can you see Exhibit 5. Then his evidence also. Exhibit
You
5.
have seen that. I've seen that. That was the first thing placed by Mr. Dott.
No, Exhibit 5.
Exhibit 5, Achana. Where is that?
Exhibit 5. Just a minute, Maharaj. I'm reading Maharaj, Exhibit 5.
Is it annexed?
Yes, ma'am.
Which page?
Yes,
Exhibit 5 is page 44 page.
yes, Exhibit.
It is to be compared with Exhibit 5.
After
Exhibit
40.
5 has been.
This is your husband's signature.
The writing is husband.
Husband.
Sorry, signature, not signature.
It is placed by
Yes.
plaintiff themselves. So it is admitted.
So you want a comparison between these two?
Then we are also kindly see.
Mr. Bhattacharya, no defense at all for you.
But
You have appeared,
page
we have heard.
61, say
Yes.
evidence. But page 61. Page 61 also is evidence. Evidence in chief
Yes.
Husband of, that is page 61. Then, my lord,
That is your evidence.
60, yes, they're going to page 71 also.
You are fishing out evidence, literally.
Page 70.
70?
No.
No.
Page 71, page 62, page 60. Just a minute.
You're just fishing out
Paragraph
evidence.
5. I say that affirm it is submitted by the defendant.
Where are you reading from?
Page 62, paragraph 5.
Page 62.
Yes.
Yes, Mr. Bhattacharya, what is this? A part of your evidence? No, this is the defendant's evidence.
Yes.
Your husband's evidence. Yes. Yes.
I say that and affirm that it is submitted by the defendant by the defendant plaintiff using one signed blank road challenge.
Clear case has been made out.
That is
Yes.
clear case. Then, my lord, that's
Mr. Bhattacharya, this is the last day. We don't waste time. We have seen the evidence. So this is clear case. You cannot prepare yourself during argument. Sorry, no.
I
You won't give you further time.
I have given one judgment of my advocate and
What
record.
judgment? Please hand it over. Why are you waiting?
Yeah, 1961 Supreme Court.
Give a copy to him.
Yes.
Yes, on what proposition?
Can you see the head note?
Yes.
Can you see the head note?
Now,
paragraph 4 also. When a question is admissible, the document is such and such 4. Paragraph 4, my lord. Second paragraph also says that once a document has been marked as an exhibit in the case and the trial has been proceeded all along on the footing that the document was an exhibit in the case and has been used for the parties' examination and cross-examination of their witnesses. Section 36 that comes into operation. Once a document has been admitted in evidence, it is not open either to the trial court itself or to a court of appeal or
I'll deal with this. Mr. Bhattacharya, I'll deal with this in my judgment.
That's a 4 judges judgment, my lord. Your loss is possibly your loss is no. That judgment. Then paragraph 4, what is the relevant for the paragraph 4?
Yes, this is very well-known judgment. You will deal
yes,
with it.
very well-known judgment.
The defendant.
Once the document has been admitted, it has been
Mr.
admitted.
Bhattacharya, let me pass my order. You're losing the case. You're losing the case. Yes.
That is why my submission before also that is
the defendant. I'll record that. I'll deal with that. The defendant in a money suit has preferred the present revisional application against an order whereby the petitioner's application under Order 26 Rule 10 capital A of the Code of Civil Procedure, seeking the appointment of a handwriting expert to to compare the handwriting of the husband of the petitioner in Exhibit 1, a purported challan, with another document which was produced by the plaintiff opposite party himself and was admittedly executed by the husband of the petitioner, was refused. To sub next para, learned counsel for the petitioner submits that the learned trial judge resorted to complete conjecture and surmise in prejudging the evidentiary value while turning down the said application. For sub next para, it is contended that the said report of the examination report of the handwriting expert, if obtained, shall be the best piece of evidence to ascertain the dispute as to whether the purported challan bearing Exhibit 1, was merely signed and written by someone else than the husband of the petitioner, or it was actually signed by the husband of the petitioner. For sub next para, learned counsel appearing for the opposite party, plaintiff opposite party opposes the prayer and submits that the document in question has already been marked as Exhibit 1 and as such, the admissibility of the same cannot be raised at this subsequent stage when the evidence is over and arguments were about to commence. For sub next para, learned counsel places reliance on the judgment of Javed Chand and others versus Pukraj Surana, reported at AIR 1961 SC 1655 in support of his proposition. So next para, learned counsel next places reliance on Section 73 of the Indian Evidence Act and submits that in order to ascertain a signature, etc., writing or seal is that of a person to whom by whom it purports to have been written or made, the same purport to have been made, comma, any such signature, etc., or proof to the satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved, although that signature, comma, writing, comma, etc., has not been produced or proved for any other purpose. Stop. It is submitted that if the court itself compares the signature, the handwriting of the husband of the petitioner, comma, with that of the exhibit 1, comma, the opposite party shall not have any serious objection. Full stop. Next para. However, comma, the appointment of expert was rightly turned down by the learned trial judge. Full stop. Next para. Upon hearing learned counsel for the parties, comma, this court is unable to accept the contention of the opposite party. Full stop. Insofar as the marking of the disputed document as exhibit 1 is concerned, comma, the document itself, comma, although marked as an exhibit and the signature of the defendant stroke petitioner thereon admitted, comma, it is the specific defense case, comma, as borne out by the written statement as well as the evidence of PW1, comma, the husband of the petitioner, comma, is that although the petitioner signed the said document, comma, the same was a blank document at the juncture of signature and was subsequently filled in by a third party who is definitely not the husband of the petitioner. Full stop. Next para. Thus, comma, the German consideration in the on the plinth of the defense case is the veracity of the handwriting allegedly of the husband of the petitioner, comma, on the disputed document being exhibit 1. Full stop. Next para. Thus, comma, the report of the handwriting expert, comma, if obtained, comma, would undoubtedly be the best piece of evidence to prove the defense case and or to disprove the case of the plaintiff. Full stop. Next para. Apart from the learned trial judge having overlooked such obvious aspect of the matter, comma, thereby committing a jurisdictional error, comma, the learned trial judge entirely proceeded on prejudging the evidentiary value of the of exhibit 1 by resorting utterly to conjecture and his or her, judge, his own preconceived notions. Full stop. For example, comma, the learned trial judge observed, recorded in the order that it is asserted by the defendant that her husband put his signature on a blank challan, comma, which is palpably incorrect on the face of the documents and the pleadings. Full stop. It is not the case of the petitioner that her husband put the signature on a blank challan, but that she herself had put such signature and that her husband has not put in, not filled up the challan by putting his handwriting. Full stop. The learned trial judge further observes, comma, due to some unknown reason, comma, that the conduct of a person in putting one apostrophe signature on a blank business document must inherently arise dissatisfaction, double inverted mode arise dissatisfaction, double inverted close, and reservation in the mind of the court. Full stop. The court says that it is a reasonable expectation from a person of authority that he would put his signature on any document responsibility, comma, by which he means that the person shall ratify and or certify the propriety and or genuineness of the contents of the documents. Full stop. It is further observed that no person should be allowed to take such plea and evade responsibility by simply stating that he put his signature while the document was lying blank, and that if the courts meekly swallow such argument, comma, commercial immorality would be encouraged. Full stop. Besides, comma, the learned trial judge went on to observe, comma, in that case the person in whose favor the challan was executed would remain practically remediless. Full stop. It is also held that a business document admittedly bearing the signature of the executant should be rendered useless at the whims of the executor. Full stop. Next para. Such notions belong absolutely to the personal domain of the trial judge's mind and have no bearing with legal propositions at all. Full stop. Next para. Whatever the learned trial judge meant by the doctrine of commercial immorality, which he himself propounded, comma, if every document was to be taken on face value, comma, the courts the half the courts would be without any litigation to adjudicate on. Full stop. Next para. Responsibility and commercial immorality are concepts which are alien to law. Full stop. Next para. Rather, comma, when a specific challenge has been rendered in the pleadings as well as the evidence of the defendant to a particular handwriting depicted on a disputed document, comma, it is the incumbent duty of the court to permit expert evidence to be adduced on the same. Full stop. Next para. The reliance of the petitioner opposite party on section 73 of the Indian Evidence Act is misplaced, comma, since the same only propounds the proposition that in order to ascertain a signature, comma, the court has to be satisfied of the veracity of the same, and the court may direct any person present in court to write any order or figure for the purpose of enabling the court to compare the word or figure so written with any words or figures alleged to have been written by such person. Full stop. Next para. However, comma, section 73 has to be read in conjunction with section 45 of the Evidence Act. Full stop. Section 45 provides that when the court has to form an opinion upon a point, comma, inter alia of identity of handwriting, comma, the opinions upon that point of persons specially skilled in such question as to identity of handwriting are relevant facts. Full stop. Next para. Since the defendant petitioner in the present case merely seeks to prove a relevant fact by calling for an expert, comma, there was no conceivable reason why the same should have been dismissed by the learned trial judge, comma, since it has a germane bearing and is the single most important evidence which can be led to prove or disprove the defense case. Full stop. Next para. Insofar as the other contention of the opposite party is concerned, comma, the cited judgment has no manner of application whatsoever to the present case. Full stop. The same was rendered in the context of objection as to admissibility of a document, of an unstamped document, or document having deficiency of stamp duty was being considered by the Honorable Supreme Court. Full stop. Section 636 of the Stamp Act clearly provides that unless such objection as to admissibility of the document on the ground of deficiency of stamp is taken at the outset while the document is marked as exhibit, comma, the same cannot be raised later. Full stop. However, comma, subsequent judgments of the Supreme Court itself have diluted the said proposition as well, comma, since the court is not debarred, comma, even if the parties are, comma, from looking at the admissibility of such document at the stage of hearing. Full stop. Be that as it may, comma, such objection pertains to admissibility on a specific question of deficiency of stamp, comma, which is not the present case. Full stop. Next para. Another important and well settled proposition of law is that there are two sorts of objections which can be taken to a piece of evidence, hyphen regarding admissibility and regarding evidentiary value. Full stop. It has been settled by a long line of decisions of the Supreme Court that the two operate in different fields. Full stop. Whereas the question as to admissibility of an evidence has to be taken, objection as to admissibility of an evidence has to be taken at the point when the document is sought to be marked as exhibit and cannot later be taken, comma, a question as to evidentiary value of the said evidence can be taken at any point of time at the time of before the trial is over. Full stop. Next para. The question raised by the defendant petitioner in the present case is not one of admissibility of the document, but of the evidentiary value of the same. Full stop. It is trite law that mere marking of a document as exhibit does not necessarily mean that the veracity or authenticity of the contents thereof are automatically taken in evidence or become sacrosanct. Full stop. The nature of objection here is that the defendant petitioner admittedly signed the Exhibit 1, full stop, thus, comma, there is no question as to admissibility raised here, full stop. The doubt raised is as to whether the document, comma, at the time of signing was blank and subsequently filled in by some person other than the defendant petitioner's husband. Full stop. For that purpose, comma, the defendant petitioner has merely sought for an expert to compare the handwriting of the husband of the petitioner from a document within bracket exhibit 5 bracket closed, which has already been marked by the plaintiff opposite party himself, and thus is obviously an admitted signature of the husband of the petitioner. Full stop. A mere comparison between the said signature, said handwriting of the husband in exhibit 5 with that purportedly written by him in exhibit 1 is what is required for a proper and complete adjudication of the suit and has been sought by the petitioner. Full stop. Thus, comma, the learned trial judge went tangentially, comma, completely on extraneous considerations in dismissing such prayer of appointment of handwriting expert. Full stop. Accordingly, comma, the impugned order cannot be sustained from any perspective whatsoever. Full stop. Next, hence, CO 15 of 2023 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 77 dated January 25, 2023, passed by the learned civil judge, senior division at Jalpaiguri in money suit, it should be. The title money you have written. In money suit number 34 of 2015, whereby the defendant's application under Order 26, Rule 10, capital A of the Code of Civil Procedure was rejected. Full stop. The said application of the defendant's petitioner is hereby allowed, comma, thereby directing the learned trial judge to appoint a handwriting expert to ascertain, to compare between the signatures, compare between the the purported handwriting, the alleged handwriting of the husband of the petitioner in Exhibit 1 with the admitted handwriting of the said husband in Exhibit 5 in terms of the prayers made in the said application. Full stop. It is expected that such exercise of appointment of experts shall be concluded by the learned trial judge expeditiously, comma, preferably within a fortnight from the date of communication of this order to the learned court below. Full stop. In view of the long pendency of the suit, comma, it is expected that the same shall be decided expeditiously. No order as to costs. Can is still pending. What is the can?
No, can is
Urgent certificate copies. Thank you. Next. Thank you. Next.
My lord, in the next matter, I am appearing on behalf of the petitioner, my lord. May I be permitted to join virtually?
Yes.
Item number 6, Lordship. I'm extremely sorry, Mr. Shubhotosh Dhar is appearing for the opposite party bank, Lordship. His personal difficulty in praying for adjournment, Lordship.
Look, the urgency was this
Yes.
revision challenges the manner in which the Section 17 application before the DRT was disposed of without granting any opportunity to the petitioner to file written objection to a maintainability of application filed after closure of the arguments. The matter was fixed for judgment. Put up was filed seeking filing an application and challenging maintainability on the ground of limitation. And we were not allowed to participate. We were not allowed to file our written objection.
Mr. Banerjee, you are enjoying an interim order in this?
Yes, but the urgency is, well, in spite of the interim order, the bank has behind our back proceeded, obtained an order under Section 14 and forcibly taken possession in the meantime.
But since he's in difficulty, let us put it after the vacation till the next circuit, and I'll record your submissions, Mr. Banerjee.
But only one thing in the meantime, the property may not be registered to any person. Well, may I pray that? Because it will again.
Yes, Mr. Dhar, there will be status quo regarding the property, subject property, for a limited period.
Well,
when the matter is called on for hearing, comma, and an adjournment is sought on behalf of the opposite party. You're for the bank, Mr. Dhar?
Yes, Mr. Shubhotosh Dhar is appearing for the bank.
Adjournment is sought on behalf of the opposite party number 1 bank. Full stop. Next para. Learned counsel for the petitioner argues that there is extreme urgency involved since despite the interim order granted by this court, comma, the bank has proceeded to implement the impugned order and take possession of the property. Full stop. The petitioner apprehends that the property will be dealt with in favor of third parties in the event such an action is not protected by an interim order by this court. Full stop. Next para. In view of the fact that there is extreme urgency involved, but the matter is being adjourned on the prayer of the opposite parties, comma, the opposite parties are restrained by an order of injunction from dealing with and or encumbering and or creating third party interest in respect of the suit property as on date till September 15, 2025 or until further order, whichever is earlier. Full stop. On the prayer of the opposite parties, the matter is adjourned till the next circuit.
Grateful, Your Lordship. Deeply obliged.
Affidavit of service filed to be kept on record. Thank you.
Grateful.
Mr. দেবশ্রী ধরের নামটা রেকর্ড হবে।
Is grateful, Lordship. Grateful.
Yes.
But I am for the opposite party.
Yes. Yes, Mr. Mukhopadhyay.
And in this matter, my lord, I am appealing for the petitioner.
Yes, Mr. Rai.
Well, this is an application, what is suit for declaration and for partition has been filed by the opposite party. There, my lord, he is
Hey,
claiming to
Dipankar. CPC to them. Yes, sorry, Mr. Rai, please continue.
in such a suit, my lord, he is claiming to be the one of the legal heirs of the original
Please once repeat, what is the suit for?
suit for declaration for partition.
By
Filed
you or
by-
them? By you or them?
By them.
Acha, partition, yes.
So,
Then,
the Usha Rani was the original owner.
yes.
She
Mr. Rani.
died behind legal heirs, out of whom they are also one of the legal heirs.
Right.
But property was transferred by defendant number 1 to 13 in favor of this defendant or the opposite party, where they disclosed that the Ushani died, leaving behind the heirs are already party to this deed. And for the purpose of federal argument, can turn to page 44 once. The deed which was executed in favor of the petitioner's hearing.
Page?
Page 44. The internal page
Yes,
21 fits up the deed.
Yes, yes. Please continue.
And last but one paragraph. And whereas the above mentioned Shwayambhu Das, man got it.
Mm-hmm.
The above mentioned Shwayambhu Das also died intestate but living behind no class 1 years. At that time of his death, as such, his share out of the aforesaid land was equally inherited by the other co-shares as per provision of the Hindu Succession Act. It was the other brothers and sisters have mentioned and transferred the entire property to the in favor of the petitioner with your lordship. As soon as he received the copy, according to us, the person who is claiming to be the heirs of Shwayambhu Das is an impostor. Because according to, he filed an application for the court below to ascertain the identity of the person who is claiming to be the legal heirs of the Shwayambhu Das. That was turned down. My lord, one thing. If it appears that he is the legal heirs of Shwayambhu Das, then my lord, he is entitled to get 1/9 share. There is no dispute about the same. From here, my lord can also. So I can file an
Trial
application.
court
for
said that
person-
trial court said that you can prove his identity in the evidence. So what is it?
Evidence.
How
My lord, can you say-
Order 10 Rule 2 is on a different footing, Mr. Rai.
Order 10 Rule 2
Just
is
to
of
ascertain the contest.
Yes, my lord. Whether the person is coming and claiming to be the heirs of the, we have raised an objection. Not can you consider when a person is allowed to proceed with the suit. If he
Mr.
can
Rai,
prove,
persons do not always come at the first stage of the suit. They may come in evidence. You may lead evidence to prove. You may call for that person to be tendered in evidence as witness. Do that in the suit. Court was right. Trial court was right.
my lord, today, my lord, you cannot, it is the case of the other heirs.
If a person comes and says that yes, I am that person, how is the court equipped at under Order 10 Rule 2 to ascertain that, Mr. Rai? You have to prove by evidence.
Then, my lord, it is the person I can raise objection that yes, what are the authority you have? Because there is a disputed claim and counterclaim.
You have already disputed that. You must have filed a written statement here.
That is not yet filed.
Then, Mr. Rai, this is premature. This is premature.
Then, my lord, I can file admitting the
It
claim.
will be open to take this point in a written statement and prove in evidence. That has been already, if it has not been clarified in so many words, I'll clarify that. You can always prove the identity or lack of identity of this person. I mean,
I can prove the lack of identity on the basis of the deed itself.
once you take it in the, you have to take it in the written statement. Provided you take it, then you can lead evidence on that. Do that. Order 10 Rule 10 is used for a different purpose.
No, may I play one thing on the subject?
Yes, Mr. Rai, absolutely.
Is a suit for partition. It will take, if that issue be taken up first, then my lord,
No, Mr. Rai, because of Order 14 Rule 2. That issue is not a pure question of law. That also you know my answer on that.
Order 40 rule
This is
2.
one of the usual matters of Mr. Mukhopadhyay. The usual matters, not the unusual good matters. I know
My lord,
best because I used to do his matters. Some of his matters at least.
Order 40 rule 2, my lord, whether that decision can be taken into, my lord. If that is so, my lord, there is no question of fighting this litigation for never-ending period.
This is first of all premature. Secondly, you can prove it in evidence, and probably that is the view taken by the trial court. Let us see. However, the matter in inquiry is not identifying. If the identity is challenged, ample opportunity of proving the same during the trial. Perfect. One of the good orders, I say. No, sorry, Mr. And sorry, Mr. Mukhopadhyay, and sorry, Mr. Ghosh, for depriving you of the opportunity to have the privilege of arguing. The present challenge heard learned counsel for the parties. First up, I'll forget that at the end, so I put it heard learned counsel for the parties. The contention raised by the defendant stroke petitioner in a partition suit is that the learned trial judge erroneously rejected an application of the petitioner under Order 10, Rule 2 of the Code of Civil Procedure, seeking an examination of the plaintiffs in the suit. First up, learned counsel, any particular plaintiff's identity you are objecting to?
He is the sole plaintiff.
Acha, very well.
Sole plaintiff.
The plaintiff in the suit. Full stop, next para. Learned counsel for the petitioner submits that an examination at the outset of the plaintiff himself would resolve the issue as to whether the plaintiff has been set up fictitiously by impersonation or is the genuine plaintiff. Full stop, next para. It is argued that since the issue of identity has been raised, comma, the learned trial judge ought to have granted the prayer of the petitioner and examined the veracity or authenticity of the identity of such person at the outset. Full stop. Alternatively, comma, learned counsel for the petitioner submits that at least the said issue should be taken up first as a preliminary issue. Full stop. Next para, learned counsel for the defendants opposite parties disputes the propositions raised by learned counsel for the petitioner. Full stop. Learned counsel submits that the learned trial judge was justified in observing that the question of identity can be raised at further stages of the suit. Full stop. Moreover, comma, no written statement has been filed as yet. Full stop. Next para. I find from the records that the defendant stroke petitioner has not yet filed his written statement. Full stop. As such, comma, the dispute as to identity of the plaintiff, comma, sought to be raised now, comma, has not even been raised in the pleadings, and it would be absolutely premature to permit an examination of the identity of the plaintiff at this stage. Full stop. Next para. Secondly, comma, Order 10, Rule 2 of the Code of Civil Procedure, comma, which has been sought to be invoked, is not for the ascertainment of identity of the parties, but to ascertain the scope of disputes raised in the suit and or to elucidate the matters in controversy. Full stop. Thus, comma, the said provision was sought to be invoked erroneously by the petitioner. Full stop. Next para. Thirdly, comma, the learned trial judge was perfectly justified in observing that the controversy as to identity of the plaintiff, comma, if raised, comma, can very well be proved later during the trial. Full stop. Next para. Thus, comma, this court does not find any infirmity or jurisdictional error and or illegality in the impugned order justifying interference with the same. Full stop. Accordingly, CO number 51 of 2025 is dismissed on contest, thereby affirming order number 09 dated March 3, 2025, passed by the learned civil judge senior division at Jalpaiguri in connection with title within bracket partition suit number 209 of 2024. Push up, no rest to cause urgency records. Thank you.
While we recorded my submission, will it be opposite party plaintiff?
আচ্ছা, যেখানে যেখানে অপোজিট পার্টি বলেছে প্লেন্টিফ অপোজিট পার্টি, থ্যাংক ইউ। অপোজিট পার্টিজ বলেছে বলে প্লেন্টিফ অপোজিট পার্টি হলো।
Sorry for all
Let
that.
me be
নো 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 কোয়েশ্চেন। Yes.
Let me be watching.
Certificate copy of the order.
What happened? What is there? Yes.
kindly see the paragraph 1 and 2. Only record this submission.
What submission?
The submission of application under order 10 road cooler.
I've passed my order, Mr. Yes. What is this matter? Yes, Mr. Datta.
The affidavit of service.
Lordship, I'm applying for respondent number 1. I'm seeking adjournment for next cycle. Just I have got the brief today and yet to receive my VNAMA also.
Come back. Affidavit of service filed to be kept on record. Full stop. What is your full name, please?
Partho Bhomik.
Mr. Partho Bhomik, having instruction to appear for the opposite party number 1, submits that he has only received the brief today and is yet to file his power. Full stop. As such, on the prayer of the opposite party number 1, comma, let the matter stand adjourned till the next circuit. Sorry, Mr. Datta. Yes. Please write your name on a slip of paper, whoever is appearing for the part. 9, yes. Yes. What is the application?
Here's the delay in paper.
नहीं एखाने? हाँ, ना.
The affidavit of service, Lordship.
Good service affected?
Service.
What is the delay?
300 something, Lordship.
What is the reason?
This is, Lordship, paragraph number 5 onwards, Lordship. There are different multiple reasons, Lordship.
You are the mother.
Yes, Lordship. Wife, Lordship, wife.
Wife, that's it. The wife of the deceased, it's a case of death.
This.
Wife of the deceased victim is the appellant before this court. Full stop. The present application is one for condonation of delay in preferring the appeal of about 467 days. Full stop. Next.
It is as per my
Calculation.
I
Let us.
That is the
I'll check up. I'll check up. 466. 466 days. Full stop. Next para.
One day less.
Affidavit of service filed to be kept on record. Full stop. It transpires that despite service, none appears on behalf of the respondents.
That's point number 1.
You have served only on respondent number 1.
Yes, as per the direction, Lordship.
That's what. None appears for the respondent number 1, comma, which is the 2 is the owner or what?
Who is the owner?
Respondent number 1, comma, which is the primary contesting party. Full stop. Next para. From a perusal of the application for condonation of delay, comma, it transpires that sufficient explanation of the delay has been given. Full stop. Apart from the illness of the petitioner for a period in the interregnum, comma, time was lost by the petitioner in moving from advocate to advocate. Full stop. Next para. Thus, comma, since sufficient explanation has been given, comma, can 1 of 2024 is allowed, thereby condoning the delay in preferring FMAT within bracket MV 89 of 2024. Full stop. There will be no orders as to cost. Full stop. Next para. FMAT MV 89 of 2024 is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. No, there is no question of an interlocutory application here. I'll direct the paper books to be prepared and
Paper books and trial court.
yes, the usual things. The appeal, you also put in requisites because notice of appeal has to be served through court.
Only upon respondent number 1, Lordship.
Why the opposite owner did not contest?
Not contest before the trial court.
Very well. No, but difficulty is if the owner, suppose we hold that the insurance company has no liability, then it shifts to the owner.
Only actually interest point. We are challenging
Oh,
only
very.
interest point.
They have paid you, but the interest
Yes,
has
Lordship.
well. Then it. Acha. And then next para. In view of the opposite part of the respondent number 2 owner having not contested the proceeding in the first forum, as well as since the dispute involved in the appeal being primarily restricted to the interest component of the sum disbursed by the insurance company, comma, service of notice on the respondent number 2 is dispensed with, full stop. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent number 1 within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. The paper book shall be prepared, the requisite number of paper books shall be prepared and filed by the learned advocate for the appellant within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty is given to the parties to mention the appeal for inclusion in the list before the appropriate bench of this circuit as and when the appeal is ready for hearing. Thank you.
Grateful, Lordship, deeply grateful.
Next.
Lordship, the next matter, Lordship, my Lordship would recall, there are grounds which I have taken on the last occasion in the convention delay application. Lordship.
Not sufficient.
Direction was given upon the
Supplementary.
Lordship.
Mr. Hirok Borman was probably, he fell down the stairs or something like that.
Lordship, yes.
So we'll put it in the next circuit.
Next circuit, Lordship.
Yes. Supplementary affidavit filed in court today on behalf of the appellants be kept on record. Have you served copy of this
Yes,
one?
Lordship.
It is submitted by learned counsel for the appellant. That copy thereof has already been served on the learned advocate for the respondent.
Affidavit, sir.
An affidavit of service in that regard is filed today and kept on record. Full stop. However, comma, since the respondents are not represented today by counsel, let the matter stand adjourned till the next circuit.
Grateful, Lordship.
Thank you. Next. Appealing for the respondent.
I'm led by Mr. Pavan Gurung. He is on the virtual mode.
Lordship, this is the affidavit of service, Lordship.
What is this? Section 5.
Section 5.
You are for the insurance company.
Yes, sir.
Here also interest or what?
Interest part, Lordship. Only interest part, Lordship.
What is the reason?
Pardon? Section, paragraph number 5 onwards, Lordship.
Let me check the delay first. কিছু বলবে? না না আছে। What is the delay? On the
As per my calculation.
oh আচ্ছা আচ্ছা yes about 22 8 মানে 8 গেল 8 39 plus 1 মাস yes as per your calculation
950 days as per my calculation, Lordship.
950
days, Lordship. As per
no,
my
not so much. Oh yes so why so long?
Yes, different, but actually these people are rustic person, Lordship. Actually, they do not know what's going on actually, and they don't have an idea about the
The
procedures.
entire family is before the court, wife and the children.
Lordship.
Appellants are the wife and the children of the deceased.
Mother, wife, and minor daughter.
Mother is also there.
Mother, wife.
Oh yes, mother, wife and the
Minor daughter. Petitioners.
yes, financial incapability is a very good ground.
Lordship.
Mr. Gurung is also not there, so we'll take advantage.
I was instructed by him to.
So tell Mr. Gurung that I'll pass the order. Affidavit of service filed to be kept on record. Full stop. Learned counsel. No, but it transpires from the application for condonation of delay that the primary ground pleaded in the application is the extreme financial constraints of the family of the appellants, comma, particularly on the demise of their only family member, comma, for whose demise the compensation has been claimed. Push up next para. Upon a thorough perusal of the pleadings of the application, comma, I find sufficient reason in the delay in preferring the same, comma, inasmuch as the appellants hail HIL from the marginal sections of society and were also hit by the pandemic situation for a considerable time during the period of the delay. Push up. The appellants also had to contact advocates and being naive people, comma, were not well equipped socially to handle their litigation, handle their prospective litigation, and as such, the delay delay in preferring the appeal ought to be condoned. Full stop. In view of the above, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT MV 31 of 2025. Full stop. The appeal is admitted and shall be heard on the grounds as taken in the memorandum of appeal. Full stop. In view of the appearance of the contesting respondent number 1 through its learned advocate, service of notice on the respondent number 1 in respect of the appeal is dispensed with. Full stop. Since the respondent number 2 owner did not contest in the trial court, in the court below, as well as the component of interest payable by the insurance company is the primary dispute in the appeal,
My lord, I'm interfering, lordship. Actually,
Not
this is
interest.
the ground, lordship.
Acha.
Interest is not the ground. Ground is, lordship, last year's actually this was an income tax pay, lordship. So, but here in this case, 4 years income tax or an average income tax has been taken into consideration.
No,
Whereas
then if the interest, the insurance company, did they say that they don't have liability? Do they point out to any fault in the insurance policy or anything like that?
no, insurance company, there is no fault, lordship. Actually, challenging the order of the passed by the trial court, lordship.
Not that. The insurance company, if the insurance company seeks to evade liability by saying that there is some defect in the insurance policy taken out by the owner,
No, lordship.
then the liability will go to the owner.
No, lordship. Actually, here the point is the deceased was an income tax pay.
That's a different one.
So
Then
last year's income tax should have been taken into consideration.
understood, but then should the insurance company then, if they did not take a point regarding deficiency in the insurance policy, then liability is cast on the insurance company otherwise.
Lordship.
So this is about whether we should dispense with service on respondent number 2.
Yes, lordship. Actually, owner has not contested before the.
আচ্ছা কন্টেস্টেড পার্টটা যেটা লাগলাম এন্ড বলে এখানে শুরু করতে যাচ্ছিলাম এন্ড বিকজ দি কোশ্চেন ইনভলভ নাকি বলছিলাম
We have come before lordship for the enhancement.
আন্ডারস্টুড ইয়েস as well as থেকে কেটে কোর্ট বিলো সার্ভিস অফ নোটিস অফ দি অ্যাপিল অন দি রেসপন্ডেন্ট number 2 is dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants. First of liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you.
Last matter, actually, number 12. Last matter, lordship, your lordship would recall, lordship, with supplementary affidavit. Direction was given, lordship.
You're for the insurance company?
Lordship, this
Here also the owner did not contest.
lordship, only point is interest.
You have given a copy to them.
Actually, yes. And this
What is the delay?
This affidavit is sorry. Delay is the matter, lordship. Exorbitant delay, lordship. That is the point, actually. That is the grounds are not sufficient, lordship, as per your lordship. So supplementary file, lordship. I have taken out different grounds.
What is the delay? Let us see.
Delays or exorbitant delay, lordship? I don't want to mention the delay, lordship.
Let us see.
As per my calculation, 1880, lordship.
ওটা কোথায়? মেমোটা কোথায়? 1075, much less in the calculation.
Less.
What is the explanation?
Actually, expression in the supplementary affidavit, lordship. So now I have taken different down, lordship.
Previously you had abused your advocate.
No, not advocate, lordship. I was actually, my allegation was against the copying section and all the code. So that is why I apologize, lordship, and I have corrected myself.
No, if there is a genuine grievance, you can take that.
Lordship.
I mean, it should not go out to the litigants that we shy away from curing our own defects, the judicial system.
Lordship.
If it's the copying section's fault, why not? But then a lot of inquiry will have to be gone into, which will take much more time.
Lordship. Actually, my junior doctor actually, I just corrected myself.
She spoke the truth, but you have covered up. You and I together.
Lordship.
Yes, what is your stand?
Lordship, kindly may strong objection be noted, and we are.
Very well, understood.
Then I'll leave it to you, Lordship.
Pardon? Thank you. Very fair. What is your name?
Sayok Sarkar.
Sayan Sarkar. Sayok Sarkar. I'll mention his name, but not your name. because of his fairness.
Lordship.
And he's quite young, so. Affidavit of service and affidavit, supplementary affidavit filed to be kept on record. Full stop. The ground taken in the supplementary affidavit is relied on by the petitioner for the condonation of the delay in preferring the appeal. Full stop. Next para. Primarily, comma, the financial constraints of the appellants have been cited as the reason for the delay, comma, since they could not meet the expenses and were in a lot of pressure repaying loan amounts due to the demise of the victim. First of next para, learned counsel, Mr. Shayok Sarkar. Yes. Mr. Shayok Sarkar, comma, appearing for the insurance company, strongly opposes the application. First of next para, upon careful consideration of the submissions of parties and going through the pleadings, comma, this court is of the opinion that keeping in view the financial difficulties of the petitioners, appellant stroke petitioners, comma, the delay occasioned in preferring the appeals ought to be condoned. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring appeal. Next para, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Push up. In view of the respondent number 2, in view of the other, which of the respondents are the owners? Two
Two is the owner and one is the insurance company.
Same here, not opposed in the code below.
Lordship.
Since the respondent
It's
number
only interest point, Lordship.
since the respondent number 2 stroke owner did not contest the proceeding in the trial court, in the court bill. Revolves around the interest component payable by the insurance company, that is the respondent number 1, comma, service of notice on the respondent number 2 is dispensed with. Full stop. In view of appearance of the respondent number 1 through its learned advocate, comma, service on the respondent number 1 is also dispensed with in respect of the appeal. Full stop. The appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Deeply grateful.
Thank
Lordship.
you.
Deeply grateful, Lordship.
Yes. And best wishes to all of you.
Thank you.
Lordship, I am appearing on behalf of my senior, Rishin Chakraborty.
Who is appearing?
Rishin Chakraborty actually is the junior.
No, he has come to court.
No.
But his name then cannot be recorded.
Since you are appearing, your name will be recorded.
No. Today, if he's not in court, then his name.
No, he is not.
No, you have argued, I have recorded your name.
Lordship, safe journey from this side.
Thank you very much.
Great.